My lord, so far as the matters posted for mediation, item number 15 is asked when me and my colleague for the other side of state of Nagaland is representing me, lord. But all we pray, my lord, today, I presume there would not be any argument in these matters. Only the matter will be referred to mediation. Now, my client is too old a lady and too sick. So probably she has to be brought from Nagaon to here. So could I pray for an early date? That's what I'm trying to say. With consent of the other parties. She's available for the other side.
Next item.
Gotcha.
But I beg to mention for listing of a WPC lordship.
But
But on 29 date. What's it? Under similar prayer.
Please, Lordship. I beg to mention listing for a WBC Lordship. Admission column on 27 Lordship next week.
see,
Oblige, Lordship.
Lordship, I beg to mention the listing of a writ petition pertaining to service matter.
when do you want?
Lordship, kindly next Friday,
Next, right?
6th.
Other similar for listing admission matter also.
When?
Also next week.
Please, Your Lordship, I beg to mention item number 31 of today's daily list may be adjourned for the day, Your Lordship.
Do you want to?
Yes, Your Lordship.
The prayer being made by Miss.
D. Chauhan.
This open Colonel Contempt for the applicant. The matter is that's adjourned for the day.
Oblige you.
My lord, I beg to mention item number 18 of today's list, my lord. An affidavit in reply has been filed today. Please allow the requisition of the said affidavit in reply, my lord.
Pardon?
My lord, an affidavit in reply has been filed in WPC number 5846 of 2021. Kindly allow the requisition of the said affidavit in reply.
May I please, Your Lordship? Lordship, requesting for listing a matter on 27. It's
Seven.
highest evidence. It's yes. No order. Highest evidence. Fits me.
Yeah, please, Lordship, I beg to mention item number 2, Lordship.
Number?
2. Lordship, the guest council is out of station, Lordship. Kindly agenda matters for a day.
The prayer being made by Miss.
L. Borua. Yapo, M. Deka.
Learned counsel appearing on behalf of
M. Deka. M. Das.
Miss M. Das. Adjourned for the day.
Oblige.
Written in fact then. No, please, written it to. এখন দিছা instruction কাৰণে আসলে আমি my lord, from my instruction, Lordship, kindly see. First of all, my lord, this is guidelines. Guidelines, Lordship, kindly see page 1 and next to page 2, 9 history. The history is the practical subject, my lord, and column, my lord, Lordship, kindly see 9. Serial number 9, internal examination should strictly verify the subjects as per the higher secondary final examination 2025 admit card. Candidate will be allowed to appear practical examination only in the subjects printed on the admit card. 10. Head of the institution and internal examiner will jointly enter the secured marks into the online portal. Before entering the marks into the portal, head of the institution and internal examiner both will cross-verify the roll number wise marks carefully. Please note, marks once submitted in the portal cannot be edited. Printed marks file will have to be uploaded in the portal duly signed by internal examiner, external examiner, and head of the institution for completing the process. The 3 persons are to sign. Lordship, kindly see this one, this one. my lord, this was a marks, my lord. Marks and absent and except, my lord. Signature below, my lord. Internal examination, external examination, and hereditary system. These are the, as per the guidelines. Already in the guidelines, Proceed kindly see this paper, my lord, CL number 78. CL number 78, the petitioner rule number, registration number is 047112/2003-2004, and number is 10178, absent. So they have sent it to the portal, absent. Then how they can claim that she was present at that moment? They are claiming on the basis of the document, Lordship, I kindly see, I have seen it, my lord, is how that document can be made. Lordship, please kindly, Lordship, please kindly see 36 of the deed petition. 36 is a marks foil. It is signed by internal examiner. Name is defined, my lord. Who's put the signature in the with the external examiner and institution, my lord, sent to the portal. This was the internal examiner is defined, and is a defined. It's a bindita something is, and there she cannot put this signature alone. The external signature must be there. Where the external signature marks is given by the external examination, not internal. Internal or the subject is a object subject, and he will introduce the, oh, this is my student, who is present, who is absent, he will count it. And now marks given by the external only. I am external examiner, I am called by the, I will call to examine the examination in someone college, I will give the marks. I will see their practical. Internal, no. And internal, they can only see who is present, who is absent. Now this is made by them itself. I don't know. The signature is also different, and this cannot be. This cannot be. So the petitioner is not entitled, my lord. Lordship, kindly see page 38. Rule number so and so, history. And here is so and petitioner's name and external signature is there. So the marks are given by the, this shown by the internal examiner is nothing, my lord. It is a self-made proper document. This is only the document where they have put signature, 3 of them, but they are sent to the board, and board has accordingly put to the portal. Now they cannot change it, my lord. As per regulation also, once it is, my lord, marks, once submitted to the portal cannot be edited. Printed marks foil will have to be uploaded in the portal duly signed by the internal examiner, external examiner, and the head of the institution for completing the process. Once submitted, there would be no scope for editing present absent status. That is our instruction.
Yeah, please, Your Lordship. Now, though I have not been given the copies which has been relied upon. Now, the Lordship, these documents which my learned senior colleague has referred to are documents which has been forwarded by the head of the institute through Annexure G, which is the principal Kachar College. He says that it is a self-prepared document. A student's career is at stake, and the Kachar College principal has annexed these documents and forwarded the same to the controller of examination way back on 5/5/2025. And the Lordship sees Annexure G, page 34. The documents which my learned senior colleague has drawn attention to this honorable court are not documents which I have produced. These are enclosed along with this letter which was sent by the principal of Kachar College to the controller of examination. And even assuming there is any defect with the internally uploading, I'll just place a judgment because my learned senior colleague was also present in a similar case which involved the Gurucharan College of Kachar. Same internal mark sheet was not, marks were not added to. Here I will take your, this is with regard to our High Court's order. Now I will draw your Lordship's attention to para 9 of that state judgment order. Here, my learned colleague has also referred to that same procedure, but this honorable court had interpreted that from a perusal and record, if I may read out here.
Yes.
Available. It is seen that it is apparent that there was due to some certain administrative shortcomings on the part of the college authorities, that the internal marks obtained by the petitioner in business studies had not been furnished, thereby resulting in marking of the petitioner as absent in the said assessment. The college authorities have admitted their shortcoming and had written to the respondent requesting necessary correction. On the other hand, learned counsel for the respondent has referred to the guidelines, which my learned senior colleague has also referred today on the examination and this. It is true such guidelines are necessary for effective management of the various roles to be played by those involved in examination process. However, when certain omissions have been made for bona fide reasons, the same cannot be overlooked, particularly when non-rectification of the same would mean that the student concerned would end up losing one academic year. So thereafter, this court, having regard to the same, this court is of the considered view that the omission that has happened requests to be rectified immediately in view of the timeline which has been provided, such and such. And thereafter, the respondent number 2 is accordingly directed to upload the marks obtained by the petitioner in the portal immediately so that the petitioner can take admission in the subject he so desires so pursue. It is, however, made clear that there shall not be as a precedent. However, the thing, Your Lordship, this honorable court, taking into the facts, had taken the stand to protect the interest of the student. Now, these documents which my learned colleague says he has doubted, this document, it appears from the correspondence, was before them in 5/5/25. And they had not even written to the student. The student wrote to them on 30th, on the very date the result was published, on 34 to 25, annexure F. There was no correspondence by them till we have come before this honorable court. And these are not documents which a student can prepare. She is seeking for her admission and taking a technical plea and debarring her because she had attended the class, she had appeared there. If there is any problem, it is between the college authorities and the state authorities, Your Lordship. So a student's career, and the last, as per my information, the last date for the admission is closing on this 24th of this, that is, though it is on Saturday, it would be 23rd for the admission, Your Lordship. And from the instruction I have received from my client, still there is a vacancy in the college with regard to one seat in the particular stream, Your Lordship.
So far earlier order is concerned, that is the first case, my lord. We take it, my lord, maybe correct. But ultimately say, my lord, the same set of advocate has brought this second case. Now we cannot be allowed, my lord, because there is a provision, my lordship, kindly see, page 38, annexure E. But she can appear only one subject history as compartmental. Then she will get the subject, certificate, if she passed. That is the page below, my lord, compartmental in history. There's a provision. She can wait for some months and she can appear, and definitely she will pass practical. You are only practical. So there is absent. Absent is correct because this document says the internal examiner cannot give marks. How he put signature in page 34. That is the whole thing, my lord. If it is lordship allow it, it will be endless witness. Other absent students are there, they will come to the court. Yes, previously that has been allowed. Secondly, that was allowed. We are third. No, my lord, it is an endless business, my lord. We cannot do it, my lord. We have already given the portal. We are guidelines were provided to in advance to the examination.
Mr. Sutia, better you file an affidavit.
Yes, you will find it. Yes.
Then anybody for
One
principal of the college?
College is the loss in the life. I was submitting because state of student life, not
Two and two.
that lots of I could have procured a
Some.
written instruction, but just the college have communicated to the department also. 24 is the last.
Who
If
have
24 is nothing happened, you will
Oh.
lost for their item.
Oh.
That's why I'm submitting.
You can do it. Oh. You come here, sir.
Department.
For the time.
Student license paper. That's why I'm submitting.
On 24th August, it will
Yes,
be closed.
midnight. In earlier case only, the court is directed, in the same day, they have uploaded and that admission is done. Is earlier case, in the same day is uploaded, as per direction of the district. As because the student career is at stake, and student there is no fault of student, no, because of college authority. That's why the last.
That was earlier projected, Ballot. Now this is Ballot, on what fault, but I don't know. The internal external examination and head institutions put their signature and send it to the portal. Now they cannot say, oh, that was wrong. She was present. No, my lord, we cannot, my lord. We will file affidavit. my lord.
Lordship,
Concern of student.
My-
No, this is not question of
Lord,
library.
it is the
Other
internal why
student,
is,
we will have to see all the student, not only particular absent.
a student's
Other
career is at
absent,
stake, your lordship, his whole career is.
cannot.
And at least the seat may be kept and reserved, your lordship, because
No, my lord, only one subject.
No, that's the only.
then the whole career will, they will delay the affidavit and it will be a never ending process.
Who says them?
24. Hotel is closed.
Maybe close, if it direct, courts direct, after filing the affidavit, court direct, definitely they do.
A statutory
No,
rule cannot
sir.
deprive a student from a rightful.
Student means,
thing.
you will have to see.
Okay, I will say, third Mr. Bisu, third of the. And here. For the respondent number. Therefore, respondent number,
2 and 4, my lord.
so that Mr. Priya for respondent
1 in 5.
1 and 5. 1 and 5. Person to order dated 19/8/2024. Mr. Supriya Karnak.
তোমার ডিপার্টমেন্ট হবে তোমার কি কব লগিয়া আছে এটা কত কি কৈছা
Instruction.
তোমার হয় নেছে
That lies the same. page.
স্টুডেন্ট লাইফ তুমি বসাবা
How about? Taking the
Sorry?
for the party which is provided that yes, of file that affidavit bringing on record the instruction received by him. This is the matter on 1 week.
one week বলো
A date may be fixed, your lordship.
no problem obliged my lord he will provide extra copy my lord
That furnish extra copy of the petition.
Fifth September.
হ'ব হ'ব
Order.
It-
Order. Taking
কি বলে?
the subject
3 September
for the parties. It is provided that one seat in arts stream in which college?
Kasar College.
Kasar college. So,
সব তাতে হবে সব প্রোডাক্ট
till further order. This recording.
Obliged, sir.
obliged
Items for reference to mediation drive. Number 1.
Another product is around the commander of the one.
Number 5.
Lordship, matter pertains to non-payment of the area salary as well as the retirement benefit of the present petitioner, your lordship. Despite several opportunity was granted to them, your lordship, no affidavit has come as yet, your lord. From that department, your lord.
No affidavit you can file.
No affidavit. Lordship, that's
Yes, madam, you are not interested to file the affidavit.
Mali, we will file, Mali. We have received instruction, Mali.
When?
Date
was-
is not mentioned, Madam.
it was earlier occasion they have submitted before this court that instruction has already come, they will.
Mali, I will file, Mali, after a week, Mali.
Even after they.
After a week, Mali.
Now you tell me Whether any purpose will be served by referring the matter to the mediation.
No, my lord, because my lord, we have denied my lord that he is eligible for my lord.
Heard, Mr. L. Mohan, learning to product. Then, Supriya for respondent saying, secondary or
Elementary education.
elementary. You,
My lord, item number 5, respondent number 7 for accountant general. S. Sharma on behalf of patient.
5 and 7.
Item 5, respondent number 7.
5 respondent number 7. M. Sharma,
S. Sharma on behalf of B. Sharma.
learned counsel, we have for please Sharma. Learned counsel product. 7.
Yes, my lord.
It is submitted at the fire. There is a listed under the column. So it is submitted to the fire. No purpose is referring the matter to the mediation. And it should be alerted. Something conflict product content elementary department of STEM. She will be filing her affidavit of opposition in week from today. Accordingly, it is provided that it's the matter for 1 week.
Date will fix it.
Okay.
Bless.
In this matter, when I've taken instructions, my lord, they don't want to go for mediation. It may come up for normal admission, man.
Normal admission.
Normal, because they are not agreeable to mediation, man.
As per my instruction, my lord, I am for the respondent number 11. They are ready to go for mediation. However, my.
Because last time they went for mediation, this court allowed, my lord, if I may just place my lord, paragraph 20, page 27. Page 27, in fact, your lordship will see, the relevant portion is at page 29. Paragraph 7. Paragraph 7, my lord. May I just read out?
So dispute between first wife and second.
Second wife.
My lord,
And as per the last order, this order, they were supposed to pay arrear with effect from April 2018. Till date, they have not paid that amount. So therefore, my lord, let your lordship will decide. Until unless there's a direction from your lordship, they will never comply. My lord.
however, the respondent number 11 is paying the half of the pensionary benefit which she has been receiving. My lord.
That he is
Till date, your lord.
that she is paying, but that arrear has to be paid.
My lord, it's a huge amount and they need some time to pay the arrear amount also. She is ready to pay the said arrear amount. However, as per
That
my
will be
instruction
recorded.
is concerned, your lordship.
Let this statements be recorded.
Yes, your lordship.
And it may come up for normal admission.
No. If the parties are not willing to go for mediation, why should we record this?
In that case, your lordship will fix it for admission.
However, however, the respondent number 11 in connection with this case, your lordship wants to go for mediation. Once again, my lord, she is also at the time of her deceased husband, she is the only wife. She is the only one who would look after her deceased husband at that point of time, my lord. And after that, this matter has come before this honorable court, your lordship. They filed this writ petition earlier occasion also. So there may be some miscommunication between the petitioner and the respondent number 11. My lord, at least my respectful submission before this honorable court is that, my lord, kindly, if possible, then send it to the mediation. As per my instruction is concerned, your lord.
That's all right. If the other party is not willing to go there, why should I refer?
Yes, sir.
Exactly.
Heard is that?
A.K. Burma, my lord.
AK Purva, learned.
SD Roy, your lordship.
SD Roy, learned.
Respondent number 11.
And you,
SB for respondent number 9.
respondent number 9 and Madam Fox.
S. Sharma on behalf of B. Sharma for respondent number 3.
Number 3. So the matter is listed under the column. The learned conflict product summits like no purpose will be served by referring the matter to the mediation. And accordingly, he tries to receive the matter for admission.
Admission hearing.
Hearing. Accordingly, it is provided that the place the matter for admission hearing on a date to be fixed by the registry.
Public.
Much obliged, your lordship.
May I please, Your Lordship? My lord, here, my lord, we put the challenge, my lord. The circle officer Morigao has shown, my lord, two wives as a legal herein, my lord, which is not permissible under the Hindu Marriage Act, my lord. So that we put challenge, my lord, so it cannot go for mediation.
Cannot go for.
Cannot.
Who is for respondent?
So, firstly, Swan. Education and state. 7 to Swan. Respondent Kuno.
I am, it's a,
Will this method for.
Admission.
yes,
Or the forming of. Madam, Lady Dorma,
respondent 1, 2, and 3.
One I.
1, 2, minute, 2 and 3. Yes, the one minute.
S. Doctor. S. Doctor for respondent number 1. Respondent number 1. The formula solids that no purpose to be solved by referring to the method of the number. No admission yet. According to the provision test, this is the method of admission yet.
Lordship, this method may be referred to mediation.
Maybe refer to the.
It's a mediation.
Yes.
I am for the police authority myself. I have done my part. Otherwise, if it goes to mediation, we don't have any problem. So far as police authority is concerned.
Third place,
AK Chopi, Lordship.
it's okay, learned council court of it.
I am B. Burman, my lord.
M. B. Burma. Learned
B.
council-
Burman for 3, 4, 5.
Learned council for respondent number 3, 4, 5, and Mr. Bhuya for respondent.
1 and 2 Lordship.
Pardon?
1 and 2 Lordship.
1 and 2.
Lordship, I am for respondent 6.
Next, your good name, please.
RR Saikia on behalf of SK.
Order, so learned council. Agreeing on behalf of Mr. S. K. Learned. Learned study council for AZ.
Yes, sir.
The research is all non-available.
The matter is state under the law. It is submitted in the bar, that the matter may be referred to the mediation, and accordingly, taking the song of the party. The parties. Referred to the Rani High Court. The matter before the mediator. And the parties are directed to appear before the mediator on. As it's stated. These are her report within the stipulated period. Before this court. This record.
Good day, Black.
9 to 12.
My pleasure. 9, 10, 11, 12, and 14. These are similar matter, but there is a legal point issue on it in this case. It come on admission.
Item number 10.
9, 10, 11, 12, and 14. 9, 10, 11, 12, and 14.
Artists of overall learned.
If open for the elementary education matter. It's a contested matter. Contested matter.
I'm for respondent number 8, Lordship.
Respondent number 8, and Madam Sharma for.
Respondent number 7 for item number 9.
Bebe.
Respondent number 7 for item number 9.
In item number nine.
I got that. Respondent number 6 for item number 12.
Number 6 in item number 12. 12. Mr. Borua learned council for the instead. In this petition, legal points are involved which cannot be resolved in mediation. And as such, Mr. Borua has conducted admission hearing. Accordingly, it is provided that this is a bit of or advantage sharing
After vacation.
after vacation.
Deeply available.
Data
Made this motion. My lord, it is a very small case. I was the headmaster, my lord. Pension has been given to me. Only thing is this rupees 40 per month with effect from 1/12/2014 is deducted from my pension amount. To that we agree, my lord. Because, my lord, from pension, they say that I have drawn some amount. That is why that is deducted. That is not proper. So, my lord, it may be sent to mediation, my lord. It's a small amount that may be decided there. But it is case of 2023. No response has been given by the authority also. It is sitting over the matter.
notice was served upon the response. Notice was served.
Notice have, my lord. I have 40.
Item 4, you are appealing.
They appeared also, my lord.
I am appealing for response number 4, Director of Pension Lord. Education Department.
Elementary.
My lord, SC Elementary Education, GA Assam, SC Finance Department.
Elementary.
They were served, my lord.
Pension.
Well, let it remain, we will bring instruction out. Mediation.
My lord, in earlier occasion, I came before a lordship because they deducted some amount which is overdrawn, alleging that overdrawn. Then your lordship decided that no, overdrawn cannot be deducted from pension amount after retirement. Now thereafter, what happened, my lord? The pension is given, everything is done, but 40 rupees has been deducted. It is against the High Court order again. That cannot be deducted. 40 rupees per month with effect from, my lord, 1/12/2014. Some area amount will be there, my lord. 14 to this 25, 10 years. Some amount.
Tell me whether we will refer the matter to the mediation.
No, my lord, let it remain, my lord. Why, my lord, this portion was deducted, we have to bring instruction, my lord.
My lord, from 23 onwards, my lord,
True, my
has
lord.
been served, no response. They are not taking it seriously, my lord. I'm
2 weeks
sir.
time may be granted, my lord. Only 2 weeks, my lord.
To bring the instruction why 4 weeks time necessary.
If your lordship
My
used
lord,
to look into the order sheet.
I'll try to bring the instruction, my lord, definitely.
My lord.
After 2 weeks, my lord.
My lord, if your lordship looked into the order sheet, your lordship will find that times and again time has been given, but after taking time, they used to forget that these 40 rupees, what is the matter? That is the.
Let them file their.
My lord.
A
A short time may be given, my lord, and date may be fixed, my lord.
Like I said, the respondent is the 4.4 is for. Those are better in this than the Departments, step for admission hearing. And meantime, he will and file his certificate. This is the matter on 19th September.
Oblige, man.
Oblige.
We have already submitted. No purpose will be served by referring the matter to the last.
My lord, still, if they talk, I'm praying for an early date if possible. The only thing was fixation of pension, whether it should be on the last pay drawn, regardless of the fact that she moved from Nagaland to NIT. That was the only thing. If they're giving to that, maybe we have a better option. May I pray for a mediation? Let us try at least. They would,
We have no objection.
they have no objection to that.
No.
No objection.
Okay. You have to appear before the mediator on or before.
10 September. 10 September.
Okay.
Oblige.
Oblige.
May I please? In this case, my lord, it's a contesting matter. Petitioner is not willing for mediation because my lord, they have filed the affidavit denying some raising some objections. We have filed a reply also.
This is the matter for admission hearing.
But this in the admission hearing that
It's a before.
For 4 to 10, my lord.
This one is number 4 to 10.
10.
It's the we have for
1 and 2 Lordship. 1 and 2 Lordship.
1 and Put best of learned for the subset for purpose with the south. Provided that after vacation.
any fixed statement.
After vacation. 22nd.
Yes, oblige.
Yeah.
My lord, in spite of the order dated 22/7/25, my lord, they have not paid the 50% of the amount.
Lordship, that,
Again, they have paid 21,000 something, my lord.
that order has
We have
already been,
also sent a letter, my lord, by registered post
that,
and paying, paid for the area also. But they did not
the
respond.
law, the Lordship, the order passed by your Lordship has already been communicated to the director, and in turn, director has already communicated to the district elementary education officer who will be taking care of that provisional pension 50% Lordship.
Then, my lord, they have to show any letter, my lord, whether they have communicated
They have only the communication
on verbal
sent by
instruction.
the director to the DO is there with me, Lordship.
If they have written any letter, my lord, they can produce before the court.
Otherwise, also Lordship, the Lordship may fix this matter for a hearing, final disposal, Lordship. We have, because the pleadings are already completed.
They have violating the order and they have paid for.
This order has been passed in regard to the provisional pension. That Lordship has passed on the last occasion, that order has already been communicated to the director, and director in turn has already directed the district elementary education officer to comply with the order in respect of the provisional pension.
Is any letter, my lord,
In
from their
respect of
side, whether they have communicated or not.
Yeah, do you have that communication?
Lordship,
Do you have that letter?
Lordship, that I have received through WhatsApp, Lordship. This. I will make it. Lordship, I have already forwarded. Mail. This communication has been made on 20th, that Lordship.
from the director to the district elementary education. May I read, Lordship? There is a 2-line letter.
The letter is otherwise ready for admission hearing.
Lordship, ready for hearing. Lordship may take it up for final disposal, Lordship. Lordship may fix a short date and Lordship,
That's all right, but for that you have to comply with the order.
Lordship, that has already been. I said I do. Lordship may fix next week for the final disposal. Meetings are complete, Lordship.
Pay the amount.
Lordship,
Must you pay the amount?
Lordship. That has already been communicated.
No, your duty will not end by sending a letter to the elementary education officer. You have to make payment.
Lordship.
Earlier, many occasions, in spite of High Court order, how they have stopped payment, that order also there. Why they have imposed compensation, that order also there.
For compliance of the order, the letter has been communicated. And submit the compliant report also.
District elementary education officer has received the inspection or not? Received this letter or not?
Lordship, that from district elementary education, I have not received yet any communication.
Complete that inspection.
Lordship.
When?
Next week, Lordship.
No, today.
Today, Lordship, at 2.
It is a clear violation of the order, man.
Lordship, at 2.
Yeah.
At 2.
Lordship.
Publish.
Lordship, my lord, I am for the petitioner.
The affidavit has not been.
Today, my lord, reply file that is all has all yet not received, I think,
After some time.
after something.
May I please, your lordship?
Yes, yes.
My lord, in fact, my lord, this matter was also heard earlier. My lord, the matter relates to, my lord, the obtaining of a B.Ed degree from an university, my lord, privately managed university is known as CMJ University in the state of Meghalaya, my lord. My lord, what has happened, my lord, under the statutory prescription and per the power conferred by the University Grants Commission regulation, my lord, the State Assembly of the Meghalaya, my lord, has incorporated an act under the name and style as the CMJ University Act, my lord, and by virtue of the passing of that act, my lord, this university came into existence, my lord. Now, my lord, and from this university, the present batch of petitioners, my lord, they obtained a B.Ed degree, my lord. And, my lord, once the B.Ed degree had been obtained, now the state of Assam is saying, my lord, that this university lacks the National Council for the Teacher Education's recognition, my lord. So, therefore, the degree which has been conferred by the, my lord, CMJ University cannot be held to be a valid degree. So, therefore, my lord, the state of Assam in the education secondary department is now, my lord, not accepting our degrees for the purpose of my lord, benefit extended to these categories of teachers for their promotions, my lord, in the post of headmaster. So this is the issue, my lord. My lord, I have to submit fairly before my lord, this issue. In fact, my lord, in some other case, by virtue of the in charge headmastership of a particular institution, my lord, in Lakhimpur district had traveled to the honorable division bench also, my lord. And the honorable division bench has passed an order, my lord, has clarifying that the in absence of the, my lord, NCTE recognition, my lord, it will be difficult to held that the degree is a valid degree, my lord. Now, my lord, I know, my lord, my learned friend on the education department will absolutely place that judgment before my lord. But, my lord, what I respectfully beg to submit before my lordship is that, my lord, there is a slight distinction between that batch, between that case and the present batch of petition, my lord, is that we are hoping for a regular promotion, my lord, and that was for an in-charge basis, my lord, although the degree is, my lord, same from the same in one university. But my lord, I have recently found one judgment of the Honorable Apex Court, my lord, wherein the Honorable Apex Court has categorically held, my lord, in a particular paragraph, that once a degree has been recognized or by virtue of the University Grants Commission Act and university is operating, then, my lord, it has already got an statutory prescription from an authority, my lord. So therefore, a separate recognition from another authority is not required, my lord. So basing on the same, my lord, principle, the Honorable Rajasthan High Court, my lord, has had absolutely upheld the degree conferred to a similarly situated institution that is called, my lord, Singhania University in the state of Rajasthan also, my lord. Now that Apex Court judgment is in my favor, my lord, but the but the Honorable Division Bench of our High Court, my lord, is absolutely against the present case, my lord. That is the factual position of this case at this moment, my lord.
Okay, you place the decision of the Supreme Court?
Yes, my lord. Yes, my lord. Before that, my lord, may I be permitted to place the facts, my lord, how we have obtained the degree?
Not required to place, required to be.
My lord. Yes, my lord, the Honorable Apex Court judgment, my lord, I have. Citation to my lord, this is a citation of 2008, 3 SCC 432, my lord. 432. My lord, I straight away, my lord, I beg to draw my lordship's, my lord, attention to the paragraph number, my lord, 22, which is at page 438, last bottom, my lord.
Yes.
My lord, may I read paragraph 22, my lord? It may be mentioned that the word institution is defined in section 2, clause E of the NCTE Act to mean an institution which offers courses or training in teacher education. As the NCTE Act does not deal with the ordinary educational institutions like the primary schools, high schools, intermediate college or university, the word institution as defined in section 2, subsection 2 only means the teacher training institutions and not the ordinary educational institutions. Hence, it is only the teachers training institution which have to seek grant of recognition or continuation of recognition from the regional committee. The ordinary educational institution do not have to seek any such recognition or continuation under the NCTE Act. In fact, the NCTE Act does not relate to the ordinary educational institutions at all. We therefore fail to understand how it can be said that the NCTE Act overrides the UP Basic Education Act and the rules made thereunder. In fact, the two acts operate in altogether in two different fields. The NCTE Act deals with the teachers training institution, while the UP Basic Education Act deals with the ordinary primary schools in UP and not any teachers training institute. The argument of the learned counsel of the respondent is thus wholly misconceived. The impugned judgment. So, my lord, what has happened in here is, my lord, the definition part has been dealt with by the Honorable Apex Court, my lord. If we go by, my lord, the meaning of institution, that the meaning of institution is defined and wherein, my lord, the universities had been excluded, my lord. So therefore, the Honorable Apex Court has held that, my lord, that those institutions, my lord, university is not included in the category of the definition of the institution. So therefore, a separate recognition from the, my lord, National Council for Teacher Education is not required. So here is also a case, my lord, the state of Assam is, my lord, not intending to accept our degree only because admittedly, because, my lord, this CMJ University do not have the recognition from the, my lord, National Council for Teacher Education, which is otherwise not required, my lord. My lord, what I respectfully beg to submit in this regard is that, my lord, an university which itself offering a course like the Department of Zoology or Department of Physics, this is also a Department of Education and which is dealing with the, my lord, the B.Ed degree and course curriculum. So therefore, my lord, it has no nexus with the National Council for the Teacher Education, which has been clarified very apparently in the judgment, my lord. Relying on the same judgment, my lord, the Honorable Apex Court, my lord, maybe the Honorable Rajasthan High Court has also passed an order, my lord. My lord may be pleased to find. Just for a moment, my lord, I beg to rely wherein because this judgment has been relied on, my lord.
Yes, which is the.
My lord. My lord, yes, my lord, in this judgment, I am relying on, my lord, from paragraph. From page 3, my lord, paragraph 5, my lord.
Yes.
May I read, my lord? Paragraph 5. The respondents have categorically averred that the diploma in education stroke B.Ed obtained from the Singhania University is not recognized by the National Council for the Teacher Education, NCTE. NCTE has taken a decision in its 277th meeting of the Northern Regional Committee held from 5th to 6th December 2017, and relevant item number 290 reads as follows. The matter regarding the complaint against the Singhania University was considered by the committee. The committee decided to issue a public notice in the leading newspaper, drawing attention of the public that the Singhania B.Ed College, Pachebari, Jhunjhunu, Rajasthan, affiliated to the University of Rajasthan, has been granted recognition by the NCTE for the B.Ed course, and no recognition for the any teachers training course has been granted by the NCTE to the Singhania University. Thus, as per the counsel for the respondents, Singhania University B.Ed College so-and-so Jhunjhunu was affiliated to the University of Rajasthan and was granted recognition by the NCTE for B.Ed course, but no recognition has been granted for the teachers training course. Counsel for the petitioner has referred to a precedent law of the court laid by so-and-so, so-and-so, so-and-so Bishnoi, decided on so-and-so, which reads as follows. The writ petition has been filed by the petitioner claiming the reliefs. It is therefore so-and-so. The fact of the case in a nutshell are that the petitioner took admission in the general nursing and midwifery, hereinafter to be referred as the GNM, and auxiliary nursing and midwifery, hereafter referred to as so-and-so courses in the respondent number 3, Singhania University, Jhunjhunu, hereinafter referred to as so-and-so university, and successfully completed the said course in a year 2014. After that, the petitioner underwent the requisite training of the 6 months in a different hospitals and obtained the certificate in this regard, and approached respondent number 2, Rajasthan Nursing Council, Jaipur, hereinafter referred to as the respondent number 2 under the Rajasthan Nurses, Midwives, Health Visitors and the Auxiliary so-and-so Act of 1964 for registration. But as per the petitioner, the respondent number 2 refused to provide registration form to them without any reason. The petitioner preferred a legal notice to the respondent number 2 so-and-so. However, despite that, nothing has been done by the respondent number 2 RNC, hence this writ petition is. Replies to the writ petition have been filed on behalf of the respondent number 1, State of Rajasthan, and respondent number 2 so-and-so, wherein it is stated that since the respondent number 3 university is not recognized by the Indian Nursing Council, New Delhi, hereinafter so-and-so, the respondent number 2 cannot register the petitioner as per the instructions issued by the INC. Learned counsel for the respondent number 1, State, and respondent number 2 have relied upon the communication dated 19/8/2015, written to the respondent number 2 RNC by the Indian Nursing Council, wherein it is stated that since the respondent number 3 university is not recognized by the INC, the RNC cannot register the persons who have completed the courses of GNM and ANM from that university. The communication dated 19/8/2015, annexed with the replies of the respondent number 1, stated that the respondent number 2 is reproduced herein below. So, my lord, this is in Hindi. Replying to the writ petition has been filed on behalf of the respondent number 3 university, wherein it is stated that the respondent number 3 university is established by the Singhania University Ordinance 2007, replaced by Act number 6 of 2008 Singhania University Act, passed by the Rajasthan State Legislation, and as per Section 2F of the University Grants Commission Act 1956, hereinafter referred to as the Act of 1956. The respondent number 3 university is a university established under the Act of 1956. It is further contended that the degrees and diplomas issued by the respondent number 3 university, which is established by a statute, are automatically recognized, and there is no need of separate recognition from any institution, including Indian Nursing Council. Learned Counsel for the petitioners and the Learned Counsel for the respondent number 3 university have relied upon the decision of the Punjab and Haryana High Court rendered in so and so in 2010, heard so and so. It is not in dispute that the respondent number 3 university from which the petitioners have passed the GNM and ANM course is a university established under a statute. Honorable Supreme Court in Dr. So and so in so and so held a degree or diploma granted by a university created by law under the law is not required to get recognition by other authority. The same view was taken by this court in the decision dated so and so, while relying on Dr. B.L. Aswa's case in Supra. The Punjab and Haryana High Court in MS Nilam Devi on the same point has held as under. So, this has been reiterated. I am reading from as stated. As stated earlier, it is not in dispute that the respondent number 3 university is a university established under the statute, and therefore, in view of the law laid down in the above referred case, that a degree, diploma, or any qualification awarded by any university established under the statute is automatically recognized and needs no recognition by any other authority. There is no hesitation in holding that the respondent number 2 cannot refuse to register the petitioners under the provisions of Act of 1964 on the ground that the respondent number 3 university from which the petitioners have completed their GNM and ANM course is not recognized by the INC. Hence, this writ petition is allowed. The respondent number 2 RNC is directed to consider the request of the petitioners expeditiously, preferably within a period of 2 months from the date of production of certified copy of this order, and if the petitioners are otherwise eligible necessary, registration is granted to them. After hearing the counsel for the parties and after perusing the record, this court finds that the precedent law cited by the learned counsel for the petitioner is absolutely covering the present dispute, as this court has held in the aforementioned precedent law that the respondent Singhania University is a university established under the statute, and therefore, in view of the precedent law, it is automatically recognized and needs no recognition by any other authority, and thus this court had granted consideration to the petitioners in that case while considering the said education to be recognized. This court finds that the condition in the advertisement on the face of it requires the qualification to be obtained from any institution recognized by the state of Rajasthan, and it is not in dispute that the Singhania University has been created by the Rajasthan Assembly by virtue of the Singhania University Pacharibari Junjunu Act of 2008, and thus the state of Rajasthan cannot say that its statutory creation is not recognized by the state of Rajasthan. In light of the aforementioned precedent law, this court views that these writ petitions and direct the respondents to consider the candidature of the petitioners within a period of 2 months from the date of production of a certified copy of this order, and if the petitioners are otherwise eligible, then the appropriate appointment may be granted to them. It is made clear that the petitioner shall not be disqualified on account of having obtained qualification from Singhania University. So, my lord, So, my lord, the law which has been discussed in the judgment is very clear, my lord. What from my limited understanding, what I have understood, my lord, is that, my lord, when a university is created by virtue of an statute in an assembly, my lord, it has already got that statutory recognition. And by virtue of the power conferred under the University Grants Commission Act, my lord, every state is empowered to, my lord, establish or create any university like in a private nature, like in our state also. My lordship is well aware there are Royal Global University is there, my lord, and other private universities, KK Handik universities are also operating. Now, my lord, if those universities is operating a department, my lord, as like the teachers training department conferring the B.Ed degree, they are not required to go for another recognition, my lord, from the National Council for the Teacher Education under the NCTE Act. This has been, my lord, clarified in the Honorable Apex Court judgment, which I have just referred, my lord. So therefore, here is in our case also, my lord, I just beg to draw my lordship's attention, my lord, that how the CMJ University had been created. For that, my lord, I beg to draw my lordship's attention, my lord, to page 58 of my writ petition, my lord. Sure, sure. My lord, at page 59, this is a CMJ University Amendment Act of 2019. I have annexed, my lord. To further amend the CMJ University Act 2009, Act number 4 of, my lord, this original act was enacted in the year 2009 and this amendment came after 10 years, my lord, 2019. This act may be called the CMJ University Amendment Act. It shall come into force from so and so. So, my lord, from this act, it is very clear, my lord, that what type of nature and duties these universities is now being, my lord, allowed to continue, my lord. So therefore, my lord, and when we are, my lord, not being sent for the deputation, my lord, we are the teachers working in the various secondary level schools of the various districts of Borpeta and Nalbari. Now, my lord, there is a, my lordship knows, my lord, that there is a provision in the Department of Education that those teachers who have not the B.Ed degree, the department takes the responsibility themselves to send these teachers for the purpose of deputation to get the, my lord, B.Ed degree, my lord, on being sponsored by the government itself. Now, but in our case, my lord, we were not sent. So therefore, my lord, on the strength of a letter, my lord may be pleased to find at page 61, my lord. Page 61, my lord, this is a letter issued by the office of the respondent number 1, my lord, addressed to the director, wherein subject is, my lord, may be pleased to find deputation to teachers to undergo B.Ed in the government B.Ed / BT colleges number so and so. With reference to your letter on the subject cited above, I am directing to say that after the careful considering the matter concerning the sending the teachers on deputation for doing the BT or B.Ed, the government has decided to continue the practice of sending serving teachers on deputations for doing BT, which is otherwise a mandatory requirement for them. In view of above, no teacher should henceforth be deputed to undergo BT B.Ed course. The teachers can and should be encouraged to pursue the BT B.Ed from any university offering BT / B.Ed through distance learning mode. So, my lord, this is a very clear and specific, my lord, instruction has been issued, and on the strength of this, my lord, we have been inspired by the department to go for the such B.Ed courses. Accordingly, my lord, we took admission in a distance mode, and accordingly, my lord, we have the degree and which has been conferred by the CMJ University. My lord, may be pleased to find our certificates is at page 63, my lord. My lord, page 63 is our certificate. My lord, may kindly see a very unique characters of certificate. This certificate has been issued by the Vice Chancellor himself, my lord. So therefore, my lord, this is exactly the similar strength of a degree like the, my lord, MSc in MSc in physics or chemistry. My lord, the certificate has been issued by the Vice Chancellor or similarly situated authorized persons, my lord. Now here is a case, my lord, from this certificate, my lord, we can presume, or my lord, it is very clear that it has, our degrees has not been conferred by the any college or the, my lord, affiliated college under the university, but by the university itself, my lord. Now, my lord, after this, my lord, when the provisions my lord, my lord, when the issue of this promotion came, my lord, that the department, the state of Assam, has never issued any public notice, or my lord, never make an attempt that notifying us to make us acquainted that you should not go for the my lord, B.Ed degree or B.Ed courses in the CMJ University or any other university like this. But my lord, when we obtain the degree, my lord, when the Department of Education is now, my lord, not inclined to accept our degrees, my lord, for not giving the benefit for promotion, then finding no other alternatives, my lord, time and again, the similarly situated as well as the present batch of petitioner did approach before this honorable court, my lord, praying for a mandamus to directing the authorities to accept our degrees. In those cases, my lord, this honorable court was pleased to dispose of series of writ petitions, my lord, and I have annexed, my lord, one of such petition, my lord. My lord may be pleased to find the operative part of the order is at page 73, my lord. My lord, I am troubling my lordship with page 72, paragraph 7, my lord. Page 72, paragraph 7, my lord. Be that as it may, it is noticed that the prayers made in this batch of writ petition are for a direction to the Commissioner and Secretary to the Government of Assam in the Secondary Education Department to give a due consideration to the various representations submitted by the petitioner. On such representations being so and so, so and so, so and so, it is understood that the similar representation have also been filed by the petitioners in other connected writ petitions also. As the prayer of the petitioner is for giving a consideration to such representation, seeking for an order to accept the B.Ed degrees of the petitioner obtained from the CMJ University, this court is of the view that at this stage, the interest of justice would be met if the Commissioner and Secretary to the Government of Assam in the Secondary Education Department gives a due consideration to all the representation of the petitioners indicated in the different writ petitions. In order to streamline the matter in a better manner, it is directed that the petitioner would file a common representation raising all the issues that may be desired to raise and to justify the acceptance of the B.Ed degree obtained from the CMJ University, and upon the same being filed, the Commissioner and Secretary to the Government of Assam in the Education in the Secondary Education Department shall give a due consideration to the same by referring and relying upon all the provisions of law as it stands today. The petitioners would be at liberty to refer and rely upon the material in order to substantiate their claim, whereas on the other hand, the Commissioner and Secretary shall also require from the appropriate authorities with the department, and if necessary from the UGC also, as regards the validity and acceptance of the such B.Ed degree offered by the CMJ University. As contended by Mr. So and so of the department, the Commissioner shall also give a consideration as to how the petitioners have obtained the B.Ed degrees from CMJ University while they were still in service. The aforesaid considerations be completed within a period of 2 months from the date on which the representation as required would be filed. In terms of the above, this writ petition stands disposed of. Accordingly, my lord, responding to the same, my lord, the Education Department has right to the University Grants Commission also, my lord. The University Grants Commission has also responded to the same, my lord. My lord, page 75, Annexure 5. Just for a moment, my lord, this is a letter issued from the, my lord, to the Principal Secretary, Meghalaya, my lord, Education Department, Joint Secretary, University Grants Commission, and the Deputy Registrar, CMJ University, Durabat, regarding the validity of the B.Ed degree obtained from the CMJ University, Meghalaya. With reference to the subject cited above, I am directed to inform you that a writ petition have been filed in the Honorable Guwahati High Court relating to a common issue as whether the B.Ed degree obtained by the respective petitioners from the CMJ University of Meghalaya are to be accepted by the authorities in the Education Department for the purpose of evaluating the qualification for the post of headmaster, assistant headmaster in the different schools of the state, and the Secondary Education Department, Government of Assam, have been asked to examine the same. Further, I am enclosing herewith a copy of the court's order dated and to request you to submit a detailed report regarding the present status of the CMJ University and the validity of the B.Ed degree offered by the CMJ University, and you are requested kindly to submit a detailed report to the government in the Secondary Education Department at the earliest. So, my lord, responding to the same, the University Grants Commission, my lord, at page 76, Annexure 6, has written a letter, my lord, to the Education Secondary Department, my lord. This is a very, my lord, elaborate letter has been written, and my lord, I beg to draw my lordship's attention by skipping the factual part, my lord. My lord, may kindly find the last few paragraph, my lord. The state government, my lord, I am reading from the last second paragraph, my lord, at page 77, my lord.
Yes.
The state government of Meghalaya has also informed that the CMG University informed that the state government that consequent upon the cancellation of the order dated of the government of Meghalaya, by judgment and order dated, the CMG University has started functioning at their permanent campus at Durabat, Ribhoi district, Meghalaya. The name of CMJ University is still included in the UGC list. The validity of the degrees awarded by the CMJ University is concerned. The same cannot be verified by the UGC. The validity of the degree can only be informed either by the state government of Meghalaya as per the order of the Honorable Supreme Court or by the CMJ University. The Joint Secretary to the Government of Meghalaya Education Department by letter number so and so has informed that the state government has taken steps to enter appearance before the Honorable Supreme Court of India for modification of the recall of the stay order and disposed of the special leave petition. For any other information in this regard, you are requested to approach directly to the state government of Meghalaya. So, my lord, from this letter, my lord, it is also discernible that the my lord, University Grants Commission has also did not dispute or has not opined that the my lord, degrees conferred by the state, the CMJ University is disputed or is not a valid one. So accordingly, my lord, this is again a letter written from the my lord, CMJ University to the Joint Secretary Government of Assam. My lord, may be pleased to find the last paragraph starts, I am reading at my lord, page 80, paragraph 8, my lord. In the instant case involving the B.Ed degree holder of this university in WPC number so and so, the teachers were enrolled in the B.Ed course under the specially crafted scheme for the working teachers, which provided for the flexible timings of studies, and regular classes were held on the Saturday evenings and Sundays. In addition, classes were held in the campus on holidays, also with the prior consultation with the student group. Since they were already serving in schools and had a good teaching experience, due credit was given while analyzing their performance. We do not think in doing so any compromise was made as to the prescribed NCTE norms. So, my lord, this
Yeah, the question is whether they have obtained pardon. And so,
exactly, my lord.
for
Such a degree, my lord.
There,
My lord, my lord. My lord,
yes, Mr.
my lord, for that, my lord, just for a moment, my lord, and for that, that's why, my lord, I have relied these two judgment, my lord. These two judgment is very categorical and specific, my lord, that when,
yeah,
my lord,
it is underlined.
my lord.
Can you ignore it?
No, my lord, because once, that's why the Honorable Apex Court under the institution category, my lord, the definition has been clarified that under the institutions, if university is included, then only, my lord, there is no compromise can be made that the NCT recognition is required. That is the, my lord, purport of the judgment which I have relied of the 2008 case, my lord, wherein, my lord, in paragraph 21, the definition of the institution has been clarified, my lord. Subject to correction, my lord, I may be wrong also, my lord. But for a fair submission before my lordship's, my lord, is that the Honorable Apex Court has clarified, my lord, that in the definition of the institution as the university is not included, therefore, the NCT recognition is not required, my lord, because it has already got a statutory recognition under the statutory creation of by an assembly, my lord.
Now, my lord, their submissions can be
Yes,
heard.
Mr. Ali.
My lord, in this case, my lord, we have already filed our affidavit, my lord, on 99/2025.
Page number.
My affidavit starts from page number 101, 107.
Yes, what is your stand?
Our stand is that that university is not recognized, my lord. Your lordship may peruse the para 4, my lord. That university is not, in fact, that university is not recognized by the NCTE, my lord. That is our stand, my lord. And requirement under the Act, my lord, NCTE Act is there, my lord. Institution means, my lord, the departments, my lord, the education department, such as Guwahati University, they have the recognition from the NCT, particularly education department. Assam University from the education department, they have the recognition from the university, NCT, my lord. The university is not required to be recognized by the NCT, but departments concerned is required to be recognized by the NCT, my lord. And in our act also, my lord, your lordship may found, my lord, institution means an institution which offers courses or training in teacher education.
Yes.
My lord, definition portion, my lord, your lordship may found teacher education. That is subsection L, my lord.
Yes. Correct.
Your lordship got it. Means the programs of education, research and training persons for equipping them to teach at pre-primary, primary, secondary and senior secondary stages in the schools, and includes non-formal education and part-time education and adult education and correspondence education. Teacher education, my lord. Teacher education qualification means the degree, diploma and certificate in teacher education awarded by the university or examining body in accordance with the provisions of this act. That means university awarded the degree, my lord, but particular department or institution, it's required to be recognized by the NCT. And then, my lord, subsection N, my lord, university is defined, means the university defined under clause F of section 2 of the University Grants Commission Act 1956 and includes an institution deemed to be university under the section 3 of this act. And your lordship may kindly come to section 14 of the NCTE Act, my lord.
Section
14, my lord.
Yes.
Every institution offering or intending to offer a course or training in teacher education on or after the appointed day may for grant of recognition under this act make an application to the regional committee concerned in such a form and in such a manner as may be determined by the regulations. Provided that an institution offering a course or training in teacher education immediately before the appointed day shall be entitled to continue such course or training for a period of 6 months, and if it has made an application for recognition within the said period and until the disposal of the application by the regional committee, provided further that such an institution may be specified by the central government by notification in the official gazette, which one are funded by the central government or by the state government or the union territory, have offered a course or training in teacher education or on or after the appointed date till
academic year 2017-18, and 3, my lord, fulfill the conditions specified under the clause A and subsection 3 shall be deemed to have been recognized by the regional committee. And then, my lord, we may skip it, my lord. Your lordship may, what is the consequence, my lord, at section 17? Contraventions of provisions of the act and consequences thereof.
Yeah.
My lord, may come to subsection 3 and 4, my lord.
Yeah.
Once the recognition of the recognized institution is withdrawn under subsection 1, such institution shall discontinue the course or training in teacher education, and the concerned university or the examining body shall cancel the affiliation of the institution in accordance with the order passed under subsection 1 with effect from the end of the academic session next following the date of communication of the said order. Subsection 4, my lord. If an institution offers any course or training in teacher education after the coming into force of the order withdrawing recognition under subsection 1, or where an institution offering a course or training in teacher education immediately before the appointed day fails or neglects to obtain recognition or permission under this act, the qualification in teacher education obtained pursuant to such course or training, or after undertaking a course or training in such an institution, shall not be treated as a valid qualification for purposes of employment under the central government, any state government or university, or in any school, college or other educational body aided by the central government or any state government. That section 17 itself, but that if the university or institution or any institutions have failed or neglect to obtain the recognition, in that case, degrees will not be a valid degree, and they are not entitled for any government job or any under the central government or state government. That is the clear provisions of law section under section 17(4).
Right, but what about your view about the referred by?
We have filed our affidavit, my lord, that para. That is not a valid degree, my lord. That is not a valid degree. But our opinion is that, my lord, they have not recognized by the NCT, my lord. That
Your opinion is all right, but what about this decision?
so far as decisions, my lord, I don't think so, my lord. It will be help to them, my lord.
Why?
Because, my lord, in para 22, my lord, my learned senior friend have the if any mentioned or the word institution defined in section 2E of the NCTE Act means the institution which offers course or training in teacher education. That means, my lord, that university particular departments is come within the purview of the under the NCTE Act, my lord. Particular department, not the university, my lord. Here institution means, my lord, because, my lord, all the university departments have obtaining recognition from the NCTE. So far as a central university or state university, even private universities are obtained from the recognition from the particular department, my lord, they have recognized by the NCTE. So in my humble submission, my lord, that judgment is not applicable in that case itself. Since, my lord, these degrees are not recognized by the NCTE, my lord.
So then we have to ignore the decision of the Supreme Court. It is your submission.
No, my lord, I am not on that, my lord. But my submission is that, my lord, so far as NCTE Act is concerned, my lord, and I am submitted before your lordship on the basis of NCTE Act, my lord. At institutes, and my lord, I have already
yes, Mr. Kaushik.
Hello.
Why?
Well, I'll straight away answer this, my lord, that this judgment is not applicable in the present case, my lord. It has been answered.
After 5 minutes.
Yes.
In the meantime, you go to the decision.
I've done through, my lord. It has been answered by the division bench. It is not applicable. Division bench has taken note of this judgment while deciding this issue, my lord.
Whether there is any.
Yes, yes. Division bench has said that this judgment is not applicable in terms of section 12A of the NCTE Act. because this is a judgment of 2008 and the NCT Act was amended in 2011. 12A, section 12A. That is, this judgment was relied by in the earlier in the revision bench also to raise the same argument that the institution is not required to be recognized if it is recognized by the university, and that has been answered by the division.
Okay. Yes.
My lord. So before I come to that judgment, my lord, first I'll just like to place the prayers in the repetition, my lord. The challenge in the repetition is twofold, my lord, and one mandamus.
Yes.
Page 54, my lord. The first challenge is to a letter dated 1/6/2023 that your lordship will find at page 100. Page 100. The first prayer is to set aside the letter dated 1/6/2023, which your lordship will find at page 100. It's a communication by the director in general to all the inspector of schools, my lord, to submit the graduation list of teachers for promotion to the vacant post of headmaster. A process was initiated for filling up the post of headmasters in the state of Assam. This was a letter which came to be challenged in this petition. And by virtue of this, my lord, there is an interim order operating where the entire process is being stalled. There is no regular headmaster promotion. Now, the second prayer is to set aside the impugn order dated 27/5/2019 and all communications issued by the NCT exercising jurisdiction over CMG University. Now, the third is directing the respondent to extend the benefit of promotion to the petitioners by promoting them as a headmaster in accordance with the process of the rule. Meaning thereby they are claiming the benefit of giving a recognition to their degree, the B.Ed degree, declaring it to be valid. Now, my lord, person to, I'll not read those orders which my senior has already read. That person to the order of this honorable court, this issue was taken up by the government and a speaking order has been passed. That speaking order your lordship will find at page 90. When this issue came up, whether the B.Ed degree of the CMG University would be accepted by the state government for the purpose of recruitment and promotion, this honorable court directed the government of Assam Secondary Education Department to take a decision. Page 90 is the order that is passed. May read from the findings. It appears that all the petitioners of the aforesaid writ petitioners are presently serving as the teachers, headmasters, in charge or principal in charge in some school of the state. They approached the Honorable High Court seeking for a direction to the respondent authority to recognize the B.Ed degree obtained from them by them from the CMG University, Meghalaya. Honorable High Court, by its order dated 39/2019, passed in the aforesaid writ petition, has given a direction to the government of Assam and the Secondary Education Department to pass a final order regarding the validity of their B.Ed degree within a period of 3 months. In compliance, the Honorable High Court ordered the department has obtained report views from the University Grant Commission, the Education Department, Government of Meghalaya, ERC NCT Bhubaneswar. From the report views, it appears that the CMJ University is not a recognized by ERC NCT Bhubaneswar for B.Ed program. Also, the said university was not authorized to open off-campus centers beyond the territorial jurisdiction of the state of Meghalaya, and also not even allowed to open any center within the state of Meghalaya as per the provision contained in UGC Regulation 2003 without approval of the UGC. After consideration of the above all other aspects, the government in the secondary had decided that the B.Ed degree obtained by the petitioner from the CMG University cannot be recognized as a valid for the purpose of employment and promotion. So, my lord, a conscious decision was taken by the authorities after taking note of the fact that the university is not a recognized degree, and it was decided not to accept this university, the degree of this university.
This has not been correct.
This has not been challenged. First, now what I understand from the context of this writ petition is, my lord, that these very petitioners, my lord, earlier instituted a writ petition which has challenged this order, and the judgment was reserved, and that the judgment was not delivered during the pendency as the promotion drive was initiated. Therefore, they have filed this writ petition challenging the promotional drive. Now, my lord, the issue whether the B.Ed degree that is conferred by an university which is not being recognized by the NCTE would be a valid degree or not, this honorable court, the coordinate bench of this honorable court, earlier decided this saying that if a degree is conferred by an institution or an university which is not recognized by the NCTE, would not be a valid degree. Well, that is Muktaram Deka's case. Now, if your lordship will kindly take the division bench judgment, my lord. My lord, that judgment I have, it is there in the record. Tag mark for us. আরম্ভণীতে থাকবে তো। Writ Appeal 122 of 2024. Lordship found it. Lordship will kindly come to para 4 first, my lord. The issue which was before the honorable division bench. Because my learned senior started that the issue would be distinguishable because that was an issue with regard to an ad hoc, not an regular promotion. But this is being answered, both are were answered. Paragraph 4, my lord. Heard so and so, learned counsel for the appellant has submitted that the order of the respondent authorities in allowing the respondent number 4 on ad hoc arrangement to hold the charge of the post of headmistress of the school by replacing the appellant writ petitioner, which was also an ad hoc arrangement, is illegal and arbitrary. He submits that the replacement of an ad hoc appointee by another ad hoc appointee is not permissible. He further submits that on the ground of the respondent that the appellant writ petitioner is not eligible to hold the charge of post of headmaster is erroneous and perverse. He further submits that the qualification for appointment of teachers in ordinary educational institutions have not been prescribed under the NCTE Act. The B.Ed degree obtained by the writ petitioner appellant from CMG cannot be said to be invalid. He further submits that since the appellant writ petitioner is senior to the so-and-so, he ought to have been replaced as the in-charge headmaster by the respondent number so-and-so. In support of his submission, so-and-so has relied on the decision of the Apex Court in Basic Education Board UP versus Upendra Rai, others reported in 2008 3 SSC 432. Well, this is the same judgment which has placed. Par contrast, so-and-so, standing counsel of the department submits that the B.Ed degree as obtained by the appellant petition. I'll come defending. That, your lordship, starts from paragraph 10. May I just read paragraph 10 that would be relevant. Apt by the amendment of Act of 18 of 2011, lordship finds paragraph 10. Section 12A was inserted in the NCTE Act 1993, which came into force on 1/6/2012, which is reproduced herein under for reference. The power of council to determine minimum standard of education of the school for the purpose of maintaining standard of education in the school, the council may by regulation determine the qualification of a person for being recruited as teachers in any pre-primary, primary, upper primary, secondary, senior secondary, intermediate school or college by whatever name called, established, run, aided, or recognized by the central government or state government or a local authority, provided that nothing in this section shall adversely affect the continuance of any person recruited in any primary, upper primary, secondary, senior secondary, intermediate school or colleges under any rule, regulation in order made by the central government, a state government, a local or a other authority immediately before the commencement of the NCTE Act 2011 solely on the ground of non-fulfillment of such qualification as may be specified by the council. Provided further that the minimum qualification of teachers referred to in the first provision shall be acquired within the period of specified in this act under the Right of Children to Free and Compulsory Education Act 2009. It appears that the council is empowered to determine the minimum standard of the education for school teachers. It is further appears that the council is defined under subsection C of section 2 of the NCTE Act, established under subsection 1 of section 3. It is thus apparent that unless the B.Ed degree obtained from a university is approved by the NCT, the same shall not be valid. Reference in this regard is also made to the decision of this court in case of Muktaram Dekar versus State of Assam, reported in 2013 4 GLT 528, wherein this court has held that the B.Ed degree obtained from CMZ University was not valid as the same did not have the approval by the NCT. Pertinent that the aforesaid judgment was decided on 24/5/2013, that is after the insertion of 12A in Amendment Act of 2011. Paragraph 12 and 13 of the aforesaid judgment are reproduced hereunder for ready reference. On consideration of all the above particular and the decision of the Apex Court in National Council for Teachers Education Supra and OM dated 9/7/2012 of the Government of Assam, and having noted that for imparting B.Ed degree by the Bharatiya Shiksha Parishad UP, CMG University, Meghalaya, Nabha Bharat Shiksha Parishad, Odisha, prior approval was not accorded by NCT to impart teachers education. I am of the view that the B.Ed degree awarded by this institution are not legally valid. Therefore, the B.Ed degree holders from such unapproved institution can claim appointment, promotion, or higher pay. It is declared accordingly. But insofar as the relevance of the legally valid B.Ed degree for the purpose of appointment, advance increment, promotion, since the issue is being examined by the division bench in the review petition, this court does not make any order on that aspect of the matter. Consequently, having declared that the B.Ed degree obtained from Bharatiya Shiksha Parishad University, CMG University, Meghalaya, Navabharat Shiksha Parishad, Odisha, which are unapproved by the NCT to be invalid in the eye of law, state is directed to take appropriate steps for ensuring that no benefit is enjoyed by anyone on the strength of the invalid valid degree secured from the institution which are not approved by the NCT. Interim order in these cases will be abide by the declaration made by this court. Cases are disposed with the aforesaid decision without any order on pause. On a reading of the aforesaid judgment, it becomes apparent that unless NCT approves the B.Ed degree awarded by CMZ University, the degree is not a valid degree. It is further apparent from the said judgment that the NCT has not approved CMZ University to impart teachers education. Hence, B.Ed degree obtained from the CMZ University cannot be said to be from a recognized university. Resultantly, B.Ed degree obtained from CMZ University is not a valid degree. In the present case, admittedly, the B.Ed degree obtained by the appellant petitioner from the CMZ University is not recognized by the NCT. Therefore, the appellant petitioner does not have requisite educational qualification for consideration of promotion to the post of headmaster. That being the position, the petitioner is not eligible to hold the post of headmaster. It is a settled law that even for holding a post on ad hoc arrangement, one must be eligible as per the eligible criteria mandated for such post. Hence, the appellant petitioner is not entitled to hold the post of headmaster even on ad hoc interim arrangement. The pertinent that the decision of the Apex Court in the case of Basic Education Board UP Supra relied by the Learned Counsel for the appearing for the appellant, having decided prior to the insertion of section 12A in the rules of 2018, the said judgment is not applicable to the facts and circumstances of the instant case. So, well, this issue has already been decided by the revision bench. So it's no more res integra that the degree which the petitioners are holding is not a valid degree to claim promotion under the statutory rules, because B.Ed is a mandatory qualification.
Okay. Yes, so Bhunya, any reply?
My lord, with all respect to the judgment which has been delivered by the Honorable Division Bench of this Honorable Court, my lord, one thing, my lord, is that as the order has been passed on a same set of subject, it has a binding effect. But my lord, only one thing is that the Honorable Division Bench has relied on the, my lord, provision of the 12A of the amendment of this NCTE Act. But, my lord, by virtue of amending the 12A, my lord, it has not amended the definition part of the institutions Act in the other category of institution, my lord. It is intact. Only the 12A is an insertion, my lord. My lord may be pleased to find in the judgment, the 12A, may I read for just a small paragraph, my lord, the 12A, paragraph 10 of the judgment division, Honorable Division Bench judgment, my lord. The power of council to determine the minimum standard of education of the school teachers. For the purpose of maintaining the standard of education in schools, the council may, by regulation, determine the qualification of persons for being recruited as teachers in any pre-primary, primary, upper primary, secondary, and senior secondary or intermediate school or college by whatever name called, established, run, aided, or recognized by the central government or a state government or a local or other authority, provided that nothing in this section shall adversely affect the continuance of any person recruited in any primary, in any pre-primary, primary, upper primary, secondary, senior secondary, or intermediate school or colleges under any rule, regulation, and order made by the central government, a state government, a local or other authority immediately before the commencement of the National Council for the Teacher Education Amendment Act of 2011, solely on any ground of non-fulfillment of the such qualification as may be specified by the council. Provided further that the minimum qualification of a teacher referred to in the first proviso shall be required within the period specified in this act under the right of so and so act of 2009 and so and so. My lord, this is very clear from the 12A is just a, my lord, amendment to the original section that the power of council to determine the minimum standards of education of the school teachers. Now, my lord, by way of inserting this, the basic of the act, my lord, the basic structure of the act, that is the educational institution which has been defined. In that definition, my lord, the universities has not been incorporated. So therefore, my lord, although, my lord, this amendment has been made, my lord, the judgment which has been, my lord, delivered by the Honorable Apex Court, my lord, which I have relied on, a statutory amendment cannot override or repeal the ratio of law, my lord, fixed by the Honorable Apex Court, my lord. Now here is an attempt has been made by my learned friend that this has a repealing effect of the judgment, my lord. My lord, my lord, I know, my lord, that it is very difficult, my lord, as
Yeah.
my lord, my lord.
It is a judgment that is finality, having not been challenged before the act.
Division bench judgment, my lord.
Yes.
No, that is, my lord, I know, my lord, that when the judgment is there, my lord, my limitation is very, very limited, my lord, to argue before my lordships, my lord, in this forum. But my lord, the ratio of law is very clearly well settled by the Honorable Apex Court, my lord. That is the binding precedent also, my lord. So my lord can consider in all these aspects, my lord, and I rest my argument, my lord, at this stage.
When the stay is operating,
My lord, yes, there is a interim order, my lord, passed from the very date to file.
So, my lord, 15/7/2024, my lord.
third prayer. Ali po.
Along my. I along. I along.
I alone. Turn it. Technical.
Engineer mo, dito wrong.
Part.
My lord, yes, respondent 1 and 2. Grateful, my lord.
My lord, highly obliged, my lord.
Affidavit twice. Affidavit I filed today, my lord, already received my reply. My lord, issue involved, my lord, for the order passed by the Honorable Court, that is 8/11/2021.
Bora, you have received affidavit.
Today I have furnace. Today morning furnace. One.
Right now, I don't have.
But one madam received.
No, that is government, my lord, department we have not received, my lord.
The department also received one madam received.
Let us go.
This is my lord reply against the affidavit in opposition filed by respondent number 5 to 7. And state respondent has yet not filed any affidavit. And they have
File the
My lord, we will file.
when
I need some time here. It is simple, my lord.
one
Here.
issue is my lord one.
no, you tell me whether your affidavit will be required or not.
Hello, we will file. 2 weeks time if granted, we will file.
My lord, it is 21 matter, my lord. My lord, order is petition filed in 2021. And long time, my lord, respondent, their salaries are stopped due to this, my lord, writ petition. The question is this, whether the writ petition is maintainable or not. That issue is involved. So that issue may be cleared by government, and these 5 years they have not filed that affidavit. And I also challenged that maintainability, and also filed one IA for vacating the interim order. So a short date may be, my lord, for
Why it is not
maintainable, my lord. It is under 2017 Act, Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017. It is specifically said, section 19, section 19, suit and proceeding. Suit and proceedings, no suit, prosecution, or other legal proceedings shall lie for anything. Page my lord to 1 to 4. This book. Section 19.
Yes.
No suit, prosecution, or other legal proceeding shall lie for anything in good faith done under this act, except with the previous sanction of the state government. Close to adjudicate disputes for redressal of grievances relating to the teaching staff of the non-government educational institution, as well as disputes concerning disciplinary action, genuineness of establishment of school, and claim for provincialization. This is the issue, my lord. Claim for provincialization in respect of teaching staff of Bhansar educational institution. There shall be an educational tribunal for each district within their respective territorial jurisdiction. The district and session judges and the additional district and session judges of each district are distinguished as educational tribunal. And they claim their service has not been provincialized. They neither approach the authority nor approach the special tribunal.
No, Lordship.
As there is a specific provision and specific remedies there, this court and this High Court is also settled this matter.
Now, Lordship, here, my lord, issue is completely
Regarding
for my friend Amir, it is not covered. Because here, my lord, the provincialization order challenged. Provincialization order, my lord, impugned because one junior teacher already been provincialized by depriving the senior one. This is the issue involved. So far this section, it is not covered in this case. And therefore, this honorable court
that issue clearly
passed
settled by this
order on 8/11/2021. The right order passed. So I am challenging, this is impugn provincialization order, where, my lord, some junior already been provincialized, depriving by the senior one. And therefore, this honorable court passed the order on 8/11/2021. Kindly have a look, Lordship, this order clearly reveal the situation. So far this
ratio is concerned, it is not covered so far my learned friends are. Ratio is quite different. Here, two junior teachers on record, that has not been challenged by the respondent number 6 and 7. They are junior, why they are being provincialized? That has been suppressed. And they are saying in another thing.
No, my lord, this suppression is very
They have not challenged that
shameful allegation against the respondents because the writ petition filed without annexing the a- appointment order, without challenging appointment order, filed this petition and saying that some allegation against the respondents that we are suppressing.
No, my lord.
Petitioner concerned himself
my lord,
suppress the
my
material
lord,
fact without annexing
let
the
me
appointment
submit my case.
appointment
Let me submit.
letters.
Let me submit. Lordship, kindly have a look, page 30. It's clearly revealed. Clearly reveal the situation, whether they are senior or junior. This DICE code 2019 is clearly revealed their status when they were appointed, when they joined.
Okay.
This cannot be jumped.
The issue is not so simple as projected by.
Yes, my lord. I'm clearly stated in my affidavit.
Quite different. That's project. Anyway, let him file a petition. Or senior
K.U. Ahmed.
okay. Number
5, 6, and 7.
Five.
5 already retired.
5, 6, and sir. Or for 1, 2, and 3. 1, 2, and 3.
Lordship, affidavit in reply filed today, my lord, that may be recorded.
Or yes. Right.
5 to 7. 5 to 7.
But it appears that the Quora part 5 Quora after one
Lordship, date may be fixed, my lord.
A date may be a date may be fixed, my lord.
system of
16. Obliged.
I love this.
Lordship, in this matter, petitioner has approached the Honorable Court claiming arrear salary. And Lordship, arrear salary was already sanctioned for the year 24 and 25, but the college could not withdraw that. So revalidation process is required for the financial year 2025 and 26, which have been now Lordship forwarded to the director has examined and forwarded to the government for revalidating that.
So when can we expect
Lordship,
completion of the process?
some time will be required because revalidation process, finance will also be involved. Already sanction was approved, everything was there, but the college could not withdraw that during the financial year. For that, that was not released. Now, from the directorate part, side Lordship, we have done everything. Now, the revalidation process is with the government. It will take a little bit time because finance will also be involved here. He is receiving current salary.
Okay.
Give me grant some time. I will have no objection, but my lord, in the meantime, my lord, that process may be completed. That is my prayer.
For which?
For which clause?
For which clause may grant?
For which may then be given.
Part 5. Okay. For higher
division.
third part.
4 and 5.
Part. the letter and the amount of but of the different equality from the finance department.
No, amount was sanctioned for the year financial year 2024-25, Lordship. That could not, the college could not get it.
From where?
From for the financial year 2025 and 26, revalidation is required. Last paragraph.
Who will revalidate it?
Government Lordship. Higher education. Higher education along with finance department will also be required. Because S1 number 3 is the finance. Their part role is also there.
Put it from finance department.
Asalia was there. Asalia was there.
Yeah.
That that's the amount sanction. By letter dated A so yes got to
Finance.
9 dated 4 required for the financial year yes then the process of time required the book
What was the rest of?
greater amount is required to be revalidated.
Yes, madam, if there is any shortfall on the part of the administrative department concerned, then only, my lord, the role of finance department will come. Otherwise, my lord, so far as payment of salary, area salary, etc., my lord, all these powers have been delegated to all the concerned administrative departments.
Okay.
Yeah, so they will have to take the call. However, if there is any shortfall, otherwise, if a person is entitled and there is a shortfall, no money in head of account or in the budget.
That's already been sanctioned.
Yes, so sanction will be done by the administrative department
No,
concerned.
that has already been done.
Yes. Now, if it goes to the finance department, then I will have to have the proposal number. Unless and until I have the proposal number, I cannot, my lord, assist this honorable court. That is my difficulty.
For which time may be granted, I'll bring the up-to-date instruction. Because revalidation is required now. That sanction order already lapsed, Lordship. Means the college could not withdraw during that financial year. So now the director has verified it. It is found in order, then forwarded to the government for revalidation. Now in the revalidation process, Lordship, government will look into it. Whether something, any updated instruction is required from the college or not, something that may be there.
There is no shortfall,
Then that is the Lordship. Already we have forwarded.
Because Lordship will kindly see this letter. My lord, this letter is from the director to the secretary higher education.
Yes.
Meaning thereby the higher education department at the school will have to take a call.
Yes.
And the higher education department and the school, if they at all find, my lord, at the end of the day that there is a shortfall, the finance department is required to be moved, then only, my lord, the role of finance department will come. So far as this letter is concerned, my lord, it is still with the education department.
Yes.
Yeah, check mark.
that's the matter. After 40 or fix it.
Fix the date. Application located in the meantime, the process will be completed. Observe that in the meantime, the process of revalidation will be completed. On 27 October, Lordship speaks the matter, 2 months almost, So Lordship observe that in the meantime, revalidation process will be completed.
That may be observed, my lord. That observation.
No, that, Lordship, I cannot assure that
observation
they
will help the
within 2 months or within that, but I have to take instruction, Lordship, because we have already, from directorate has already forwarded to the government. On sanction was given for that year, previous year. Now, yes, Lordship, that I cannot assure that, Lordship.
If there is already a sanction on record, my lord, in all possibility, it will be done.
Yes.
Fine.
Oblige, Lord.
Thank you.
In this method, we have received the instruction, so 10 days may be granted so that we can file our affidavit matter.
I have filed my affidavit, my lord, and additional affidavit also.
File additional.
I filed one.
You have filed.
Yes, my lord.
Ordinance. You, Madam, your name?
M. Bora.
M. Bora. Request of
Response number 6 one.
formal. Or I think 10 days.
10 days or 2 weeks.
Period.
Made preservable.
Yeah.
No, it's regarding selection and appointment to the post of chemistry, Basugaon College.
Yes.
My lord, I take your lordship straight to the advertisement. Lord. Department of Chemistry, Basugaon College. Advertisement is at page 29. Annexure 10, page 29 of my return. In the advertisement, my lord, the serial number 3, assistant
Page
of
number.
page number 29, annexure 10.
Yes.
My lord, in the middle portion, upper middle portion, serial number 3, chemistry. 3 post, 1 post unreserved. We are concerned with this unreserved post. Roster point 27. My lord, the petitioner applied along with other candidates, including the private respondent number 7. They took part in the election process, my lord. The call letter is next page, my lord, page 30. The advertisement was of 4 July 23, and the call letter was issued to appear in the interview on 5th September 23, page 30, annexure 11.
Yes.
Now I take your lordship to the last annexure, annexure 13.
Like that.
Annexure 13, page 33 onwards. It's a RTI reply, my lord, regarding the interview and selection process, my lord. The relevant portion at page 34, my lord. 34 and 35, the last 2 pages of my return. Serial number 2, Srifung Bosumotari, the private respondent number 7. She got selected, my lord, which the marks is important, my lord, 72.43.
Sri Phung Bosumotari, private respondent number 7, 72.43. And the next page, my lord, the read petitioner, serial number 10, Dr. Grace Bosumotari. She got 71.45, the second position. The difference is less than 1. Now, I take your lordship to the affidavit in opposition by the private respondent regarding certificate of experience, my lord. I'll be very brief, my lord. So, my lord, this certificate is the crux of the matter, my lord. That page number 69, running page. Affidavit in opposition filed by respondent number 7. Page 69. Married. This is to page 69, my lord, annexure 2 of that affidavit in opposition by respondent 7. This is to certify that Ms. Sri Phung Bosumotari, respondent 7, my lord, PhD research scholar. It is important. She is a PhD research scholar. Department of Chemistry, Boroland University has been engaged to take classes of chemistry subject since 1922 to till date. So, my lord, it is with effect from 1922. The interview was held on 5/9/23. So, due to this 1 year teaching experience, she got 1 mark. And in consequence of this teaching experience certificate, Miller, she got first position. Though the difference of marks between first position holder and second position holder is less than 1. But she got 1 mark due to this teaching experience. But what the office memorandum says, Miller, in my read petition, Miller, the office memorandum of the state government, it has been annexed as Annexure 9. Start from page 24. Dated 29 January 2022. On the basis of this office memorandum, that selection and interview was held. Page number 24 onwards. Annexure 9. Issued by Director of Higher Education, Assam. To all the principals, Miller. The next page, page 25, is the annex office memorandum, Miller.
Yes.
Page 24 onwards. Page relevant pages. The page 25, first few lines, Miller. Guidelines for selection of assistant professor in provincialized GOVT and GOVT model colleges of Assam. In partial modification of so-and-so, dated so-and-so, issued by Higher Education Department, the government of Assam in Higher Education Department is pleased to notify the following guidelines for selection of assistant professor librarians in provincialized colleges and GOVT medical colleges of Assam. Model colleges of Assam. Eligibility qualification. Qualification for direct recruitment of assistant professor, reference clause number so-and-so, UGC regulation. 1. Good academic record as defined by the concerned university with at least 55% marks. Miller, it is not relevant. Number 2. Besides, the candidates must have cleared the national eligibility test, NET, conducted by the UGC, ESIR, or similar test accredited by the UGC like SLATE, SET. 3. Notwithstanding anything contained in subclause 1 and 2 to the clause so-and-so, UGC regulation so-and-so, candidates who have a PhD degree in accordance with the University Grant Commission so-and-so 2009 shall be exempted from the requirement of the minimum eligibility condition of NET, SLATE, SET. 4. NET, SLATE, SET shall also not be required for such master program in disciplines for which it is Miller not relevant, Miller. Now, clause 6, Miller. It is important. The period of time taken by candidates to acquire MPhil and or PhD. The private respondent number 7 is PhD research scholar, PhD student. The period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience for appointment to the positions. So, my lord, during her stint as PhD research scholar, my lord, she produced that teaching experience certificate for more than 1 year, and therefore, in consequence of that experience certificate, she got 1 mark more than the writ petitioner, obtaining the first position. Otherwise, the writ petitioner would have got that first position. Now, two relevant clauses, my lord, page 28, my lord. The last page of that annexure, my lord. Clause 8. Regarding that teaching experience aspect, my lord. Page 28, clause 8. Teaching or library management experience in the concerned subject domain, 1 mark for each completed year of services after acquiring UGC norms in provincialized GOVT affiliated degree college libraries of GOVT institute, higher secondary classes of provincialized schools, subject to maximum of 2 marks. However, if the period of teaching experience is less than 1 year, then the marks shall be reduced proportionately. In this case, a minimum of 3 months teaching experience will be counted. So since, my lord, the private respondent number 7 has obtained that teaching experience certificate for more than 1 year. So in view of this clause 8, my lord, she got 1 mark, my lord. 1 mark for each completed year of service. But it is in violation of the UGC regulation as well as division bench judgment of this honorable court. My lord, since, my lord, time, my lord, add to, my lord, I think, my lord. There is a division bench judgment, my lord, and UGC regulation is also, my lord, in against the private respondent number 7 selection on the basis of that teaching experience. I'll place those.
But have you challenged this OM?
My lord?
Have you challenged this OM?
No, my lord. I have not challenged. That OM, the contents of that OM is in favor of me.
But this clause number 8.
Clause number 8 goes against the private respondent number 7. For 1 completed service year, 1 mark. But that service period should not be as a PhD research scholar as per UGC regulation and as per our division bench judgment. I'll place those documents, my lord, at 2 minutes. She completed service as a research scholar,
Not as a teacher.
not as a teacher. In their, my lord, parlance, my lord, it is called teaching assistant. So, my lord, when one is a PhD research scholar, that activities, my lord, they may take part, my lord. It is called teaching experience, teaching assistant. So that teaching assistant experience cannot be counted. My lord, I will place those documents, my lord, including division bench judgment regarding this aspect, my lord, at 2 minutes. My lord, I take your lordship again to that page 28, clause 8, regarding 1 mark for service. Lord, page 28, Lord, it's clause 8. 1 mark for each completed year. Since the private respondent number 7 completed 1 year, so she got 1 mark. But it will have to be read together with clause 6 of page 25 of the same office memorandum. The opening page, Miller. Clause 6. Eligibility qualification. Page 25. In the Miller lower portion, Miller. May I read that 6 again, Miller? Clause 6.
Okay.
The
The
period
period of time taken by the candidate to acquire MPhil
here, Miller,
or
PhD
PhD
degree.
degree
Miller. Since Miller,
shall
the
not be considered as missing from research section.
Miller. That is the moot point, Miller. Since Miller, the private respondent number 7 is a PhD research scholar. So Miller, that teaching experience should not be
During
counted,
that period not be considered.
Miller. And it would be in tune with the UGC regulation, Miller. That UGC regulation has been annexed by my learned friend. Page number 66, Miller. Affidavit in opposition filed by respondent 7, page 66. That will clarify the position, Miller. 66 onwards, Miller. Page 66, EGC regulation of 2018, Miller. We can skip the other paragraphs, Miller.
Yeah.
Miller, the paragraph 3.3, 3.1, Miller, 3.0, page 67, Miller. Mary. The direct recruitment to the post of assistant professor so-and-so in the universities and colleges and senior professor so-and-so shall be on the basis of merit through an all India advertisement, followed by selection by a duly constituted selection committee. As per the provisions made under these regulations, these provisions shall be incorporated in the statutes or ordinances of the university concerned. The composition of such a committee shall be as specified in these regulations. Now, clause 3.31. It should be through a selection process by a duly constituted selection committee as per 3.1. Now 3.3. The national eligibility test NET or an accredited test state level eligibility test SLATE shall remain the minimum eligibility for appointment of assistant professor and equivalent positions wherever provided in these regulations. Further, SLATE shall be valid as the minimum eligibility for direct recruitment to universities, colleges, institutions in the respective state only. For Assam State, Miller, there is a SLATE or SET examination is there. In addition to this national eligibility test, NET, provided that candidates who have been awarded PhD degree in accordance with the University Grants Commission so-and-so Regulation 2009 or the University Grants Commission so-and-so 2016 and their subsequent amendments from time to time, as the case may be, shall be exempted from the requirement of minimum eligibility condition of NET, SLATE, SET for recruitment and appointment of assistant professor or any equivalent position in any university, college, or institute. Now, Milord, we can skip other paragraphs. Next page, Milord. Page 68, clause 3.11. Regarding time taken in pursuing PhD degree. 3.11. Page 68. This is very vital to the petition, Miller. The time taken by candidates, 3.11. The time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the teaching positions. So this sentence in clause 3.11 is in tune with clause 6 of State Government Office Memorandum. Milord, the other sentences are not relevant, Milord, regarding further period of active service and so and so. So if one is a PhD student, then the teaching experience would be nil as per this UGC regulation. Next page, Milord, Annexure 2, page 69. I have already shown that page, Milord. It is by the private respondent number 7, Milord. This certificate clarifies that Sri Kung Bosumotari, PhD research scholar, Department of so-and-so, has been engaged to take classes of chemistry subject since 1/9/2022 to till date. So this 1/9/2022 to 5/9/2023, more than 1 year, so she got 1 mark, Milord, which is in violation of the Office Memorandum of Government of Assam as well as the UGC regulation clause 3.11. Now the division bench judgment of this honorable court, Milord, as regards that clause, Milord, whether a PhD research scholar could claim teaching experience marks, Milord. Asarani Brahmo versus Srimati Binika Goyari, State of Assam and others. Only 2-3 paragraphs, Milord. The background is at page 7 and 8, Milord, paragraph 7 and 8, Milord. Page 4 and 5. Paragraph 7 and 8. Division bench judgment of this honorable court. Paragraph 7, Milord. Mary. Being aggrieved by the order dated so and so, the respondent number 1 writ petitioner again approached the High Court by filing the caption writ petition number so and so, which was allowed by the impugn order dated 8/11/2018, which is assailed in this appeal. This order dated 8/11/2018, Milord, is under challenge in this appeal. Ultimately, appeal was dismissed, Milord. Next para. The learned single judge held that the writ appellant was wrongly awarded 2 marks of experience for the period during which she had joined the junior research fellowship, next page, Milord, offered by the UGC, and the position post reduction of 2 marks relegated her below the writ petitioner in merit. Milord, similarly situated with the present writ petitioner as well as private respondent number 7. 8, para 8. The core issue calling for adjudication of this court in this appeal is as to whether the writ appellant who had joined the JRF course offered by UGC on so and so could claim 2 marks for teaching experience after the date on which she joined such fellowship. Now we can skip other paragraphs, Milord. The last paragraphs, Milord, 28 to 31, Milord. Last 2 pages, Milord. Page 12, paragraph 28. Paragraph 28, page 12, last 3 lines. Under clause number 9 of the UGC JRF guidelines, the fellow can undertake activities other than the research program only with the consent of the guide, head of the department. No such consent accorded by the head of the department, next page, Milord, prior to the selection process in question was placed on record by the writ appellant. Even if the said aspect is ignored for the sake of arguments in order to claim benefit of 2 marks by virtue of teaching experience, the appellant would have to establish that she taught for a minimum period of 40 hours per week in terms of clause number 15.1 of the UGC guidelines. However, clause number 9 of the UGC JRF research guidelines clearly prohibits a research fellow from undertaking activities other than the research for more than 10 hours a week. Thus,
there was no possibility that a writ appellant could have indulged in teaching activities for 40 hours a week so as to accept her claim for 2 marks towards teaching experience under the said advertisement. Clause number 3.9.0 of the UGC guidelines clearly stipulates that the period of time taken by the candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the teaching positions. A fortiori, the appellant was clearly precluded from award of marks towards teaching experience in the subject selection process. Paragraph 29. By the office memorandum dated so issued by the government of Assam, the government of Assam adopted the clause number 3.9.0 of the UGC guidelines, and thus there is no merit in the argument of learned senior counsel for the appellant that UGC guidelines do not apply to the state of Assam. Now, para 30. As a consequence, we grant our full imprimatur to the view taken by learned single judge in WPC number by order dated 8/11/2018, whereby the writ petition preferred by the respondent number 1 was accepted. The appeal thus lacks merit and is dismissed as such. So, in view of this division-based judgment, the teaching experience as claimed by the private respondent number 7, it cannot be accepted in the eyes of law. And to be more clear, my affidavit in reply, 2-3 paragraph.
Yes.
Now, there is another
point?
Milord.
Any other point?
Yes, Milord. Milord, well, the private respondent number 7 filed an additional affidavit. Milord, may I draw your lordship attention to page 91.
Yes.
I take your lordship straight to para 2. The content of the private respondent number 7, Milord, that has been, Milord, incorporated in paragraph 2, page 91. May I read, Milord? It is very crucial, Milord, that the advertisement was issued on 4/7/2023, granting 15 days time to apply before the undersigned, that is the principal Basugao College. However, on proper scrutiny, it is now detected that the writ petitioner passed net on 29/7/23. That is after expiry of 15 days. It should be 10 days, Milord. That is after expiry of 15 days from date of advertisement. As such, the writ petitioner is not qualified till last date of submitting application to secure full 13 marks as per condition number 4 of the number so-and-so dated 9/2/2022, the Gov Office Memorandum, Milord, and serial number 5 of Office Memorandum number so-and-so dated 24/1/2022. So, it's regarding the marks got by the writ petitioner to telling 13 marks regarding her PhD degree. So, Milord, now I'll have to take your lordship again to the office memorandum, a different clause, Milord, clause 5. Page 27, Milord. Clause 8 was about teaching experience. Now, clause 5 regarding 13 marks to be awarded for PhD degree. The writ petitioner is PhD degree holder. She got 13 marks. This 27 Milord page, clause 5. May I read it? I'll read it slowly. Clause 5. PhD in the concerned subject from the UGC recognized university marks will be awarded only if a candidate has PhD degree. Now it is important. In addition to eligibility requirement of net slate set, off-campus PhD, it is not relevant. Marks, 13 marks. So one will have to be a PhD degree holder in addition to eligibility requirement of net slate set. The petitioner got selected in net after 10 days from the last date of advertisement. The date of advertisement was 4/7/23. Within 15 days, the application should be submitted. So it would be, the last date would be 19/7/2023. And the writ petitioner got selected in net examination, on 29/7/23, after 10 days. So the claim of the private respondent number 7 is that since that net examination has been passed by the writ petitioner after last date of the advertisement, so that 13 marks he could not get. But if we come to that office memorandum as indicated in paragraph 2, page 91 of the affidavit in reply, additional affidavit of the private respondent number 7, it will clarify that even after the last date, before the interview, if one gets that net examination passed, then it could be accepted.
Where it is provided?
This is the office memorandum, which has been indicated in paragraph 2, page 91 by my learned friend, appearing for respondent number 7. There are two office memorandum. One is 24 January 2022. That has already been annexed in the writ petition. And subsequently, this office memorandum has been issued by the government of Assam, Director of Higher Education, 9 February 2022. The paragraph clause 3 and 4, particularly clause 4. May I read, clause 4. So, as per clause 4, the eligibility like MPhil, PhD can be acquired and submitted on the date of interview and not beyond. So the interview date was in the month of September, and the writ petitioner acquired the eligibility of net in July itself. So as per this office memorandum, as indicated by my learned friend in his affidavit, additional affidavit, it is clear that this 13 marks is acceptable in the eyes of law. These two issues, of the writ petition, if, the private respondent number 7's mark of teaching experience mark of 1 mark, is less than the writ petitioner mark, then the writ petitioner will be in the first position, and the private respondent number 7 will be in the second position, the select. That's my submission.
Yeah. For private.
Hello. Let the problem counsel make some, then I will.
For respondent number 4, 5, and 6. 4, 5, and 6, Lordship. College authority, Lordship. Yeah. Not college authority. In this case, Lordship, Committee was constituted lordship as per the official memorandum of 24/1/24 lordship, 22 lordship. And the lordship, the 1 marks regarding teaching expense was awarded lordship as per EGC notification, already read lordship, 3.11 EGC lordship. In my affidavit, page number 57 lordship.
Number 50.
57 lordship, in my affidavit.
Yes.
Merit lordship. The time taken by the candidates to acquire MPhil and or PhD degrees shall not be considered as teaching research expense to be claimed for appointment to the teaching positions. Further, the period of active service spent on pursuing research degree simultaneously with teaching assignment without taking any kind of leave shall be counted as teaching expense for the purpose of direct recruitment promotion. So, lordship, as per this lordship, the private husband produced documents, expense certificate, and 1 mark was allotted to him, lordship, to her. And lordship, another lordship, the petitioner marks academic career is less than responded. So it is clearly reflected. I have all the documents annexed in my affidavit, lordship. So marks regarding difference of marks, lordship. Page number, lordship, 45, lordship.
Yes.
At serial number 2 is the private respondent. And lordship, at serial number 10 is the petition mark. So, lordship, regarding teaching expense, it is awarded as per EGC rules, lordship. This is my submission.
As per rule.
Yes, Lord. EGC notes, lordship, which I have started reading 3.11, lordship. This is my submission, lordship.
May I please, Lord?
Then I go for private response.
7, my lord.
7.
Yes. My post selection has been under challenge. My lord, on 5/6/2025, my lord, this honorable court, my lord, after filing of my additional affidavit in this matter, I raised regarding the question of maintainability and eligibility of the petitioner. Then the learned, my senior friends showed time to file an additional affidavit. I raised the maintainability as well as eligibility of his point, my lord, but no additional affidavit filed, though my learned senior friend has made an oral submission. Anyway,
With order dated.
I ordered the 5/6/2005. Lordship may see the kindly order 5/6/2025. The question of maintainability is involved in this matter.
He has not filed the affidavit.
No. Now, in lordship, why I am taking the ground of maintainability? Kindly have a look, my lord. The affidavit, the position filed by me at page 59, my lord. Only 2 paragraphs I read from my position. Paragraph 3 and paragraph 7. Only 2 paragraphs I'll read, then I will take your lordship the document that exhibited here. I will take your lordship data. And also on my this question, my lord, page number 60. May I read, my lord?
that the answering dependent before the replying to the paragraph wise averments of the writ petition question of maintainability of the present writ petition proceeding on the following grounds. Number one, my lord. The absence of any challenge to clause 8 of the office memorandum dated 24/1/2022 bearing them so and so issued by the Secretary to Governor of some higher education regarding allocation of 2 marks against teaching experience. Number 2 is important. The absence of University Grant Commission UGC a party respondent to the proceeding. Entire proceeding, my lord, the writ petitioner has to claim the violation of UGC provision this and that, but UGC is not party in this matter. Admittedly, whereas UGC is the only party here, my lord, to clarify all the situation of the norms, my lord. He is not my party, and most casual manners made in reply, I take a lordship letter. That on the ground of the maintainability itself, the writ petition is liable to be dismissed. Now paragraph 7, my lord. This is the last paragraph I'll read me. Page 61. That as regard to the statement in paragraph 5, 6, and 7 of the writ petition, the answering deponent categorically and emphatically denies the allegations baseless, unfounded, unsustainable in the law of his country. Now, my lord. The answering deponent begs to state that the post of assistant professor presently under challenge pursuant to the advertisement dated 4/7/23, OM dated 24/1/2022 issued by the Secretary Governor of Assam Higher Education does not make any mandatory requirement of the PhD degree for that post. That the answering deponent possesses all the necessary requirement as per the advertisement dated 4/7/23 of the OM dated 24/1/2022 bearing so and so qualification of the writ petition post. That at regards to the teaching experience, this is more important. Teaching experience and allocation of marks to the answering deponent. The answering deponent begs to state that as per the clause 8 of the OM dated 24/1/2022 issued by the Secretary Higher Education Department, allocation of 2 marks against the teaching experience, etc. cannot be allowed. That as per the UGC, my lord, that as per the UGC notification dated 18/7/18, I have annexed this document, my lord. The answering deponent possessing teaching experience, having engaged in taking class in chemistry subject since 1/9/2022 at Boruland University, my lord, this is the most vital word, simultaneously, my learned friend has skipped that word, my lord. I will take the lordship letter, my lord. The Boruland University simultaneously, along with her PhD research, thus the answering deponent under clause 3.111 of the UGC notification dated 18/7/18 possesses teaching experience and is entitled to allotted marks under the office OM dated 24/1/2022 to be issued by the Secretary of Assam. Now, the Boruland University Kokrajhar, in this regard, has issued a teaching experience certificate by the Registrar of Boruland University Kokrajhar dated 7/9/23. The answering deponent possesses the brilliant academic career, having the first SSLC Seva so first division in the higher secondary so first division Bachelor of Science Chemistry from the University of Delhi, first division in postgraduate MSc Chemistry in the Boruland University, had declared net in the year of 2022 before that advertisement below, and presently pursuing PhD in the Boruland University. The answering deponent begs to state that the selection committee respondent number 5 has duly allotted necessary marks against each qualification as per the OM dated 24/11 at the section dated 3.11 UGC Regulation 18. Now, my lord, I will take your lordship the kind attention at Annex 1, page 66, the UGC notification. Yes. Lordship, page 60 directly, 3.11. My learned senior friend read only 2 lines, my lord, but the latter parts which goes in my favor has not read. The time, may I read, my lord? The time taken by the candidates to acquire MPhil and / or PhD degree shall not be considered as teaching and research experience to be claimed for appointment to the teaching position. Then, my lord, my case starts from here. The further the period of active service spent on pursuing the research degree simultaneously with the teaching assignment without taking any kind of leave shall be counted as teaching experience for the purpose of direct recruitment, promotion, regular faculty members up to the 20% of the total faculty strength, excluding faculty on medical and maternity leave, shall be allowed by the respective institution to take study leave for the pursuing PhD degree. Now, my lord, I'm simply pausing on this point, my lord. My learned senior friend has played the 2 lines. Where is the subsequent paragraph? It says that for the period of active service spent on pursuing the research degree simultaneously with the teaching assignment without taking with a kind of leave shall be counted as teaching experience. Yes, my lord. Admittedly, my lord, at the time of my lord, PhD, my lord, this is simultaneous. I am doing PhD as well as my teaching, my lord. So if that be so, then the 1 marks so far as per the close date, I want that one. This very important simultaneously that specific this what my learned friend has not read, my lord. Now, my lord, though my learned senior friend has page 69, my certificate has shown lordship. I don't waste your time, lordship. This is my certificate issued. This simultaneously, I'm also pursuing my PhD degree, my lord, and more. Page 81, my lord. Page 81, the certificate I passed the NAT, my lord, that is prior to the advertisement 28/10/2022. That is my certificate, my lord. Now, my lord, since I'm specifically raised two questions, my lord, regarding my learned the writ petitioner has failed to challenge the close date regarding allotment of marks, my lord, and moreover, my lord, the entire whole case he's been saying that the violation of the UGC guidelines, UGC specific provision, but I'm very sorry to say, my lord, the UGC is not party in this case. Even in his reply, kindly, my lord, the reply filed by the writ petitioner on my opposition, kindly, my lord, at page 82. 84, yes. Paragraph 3, my lord. On this maintainability, 84, paragraph 3. That with regard to the statements made in paragraph 1, 2, 3, 4, 5, and 6 of the aforementioned affirmative opposition, while putting the respondent number 7 to the strict proof thereof and reiterating the statements made in the writ petition, further begs to state that there is no requirement, my lord, kindly noted, there is no requirement in the peculiar factual metrics of the instant writ proceedings to challenge the close date of the office memorandum dated 24/2/22 and my lord, and or for impeding the University Grant Commission UGC as party respondent the proceeding, my lord. And consequently, the maintainability as on this ground could not be considered at all instant matter. By simply, my lord, in paragraph 3, they say that the ground for not challenging the close date, why UGC has not been made party in this, simply say it is not necessary, my lord. Now, my lord, the writ petition, my lord. Page 10, paragraph 6. That the writ petitioner humbly begs to state that there has been clear anomalies as well as the illegalities in the selection recommendation in favor of the Sirfung Basumatari instead of the present writ petitioner, and further, my lord, that is, there has also been violation of the GOAT guidelines as incorporated in the OM dated so and or the UGC regulations concerned or the relevant laws of the land in the regards including the Assam College Employees 2005 rules thereunder. My lord, saying the violation of the UGC regulation, petitioner himself admitted there is a violation of UGC regulation admitted, but bare proposal, if the lordship go to, that the UGC is not at all party in this matter. Now, my lord,
The data
my lord,
or data is being claimed against the
my lord,
then whether you the party.
absolutely, my lord. Since, my lord, that OM relied by the Annexure 9, my lord, kindly have a look, Annexure 9 OM, the guidelines relied by the state of the UGC regulations, my lord, page 25. It is 24 January 2022, my lord.
Yes.
Yes, lordship will find the eligibility qualification. The qualification for direct recruitment of the assistant professor reference to the clause number 7 of the UGC regulation 30 June 2009, my lord. This UGC regulation is, this OM is, my lord, the relying the OS UGC regulation 30 2010, relying this clause has been made, but where is the UGC part? Whether the UGC is clarified on this point? What is the stand of the UGC in this matter? But no, UGC is not there, my lord. Had it been made the party, the UGC could have done stand taken the what the question, the point raised by my learned, writ petitioner as well as the private respondent on this point. But UGC is not allowed party in there, but absolutely necessary party. In this, even this honorable court had interfered on this point when the necessary party is not even dismissed, my lord, on merit, dismissed, thus because not taking up the necessary party in this. My admittedly in this case, my lord, writ petitioner from saying that the violation of the clause of norms of the UGC norms, even state government has relied on UGC norm, but UGC is not before this court, my lord.
The point in the guideline.
By UGC guideline, my lord, this eligibility criteria, my learned seniority language, clause number 6, my lord, Roman 6. Roman 6, my lord. It is the guideline of the UGC, my lord, that the period of the time taken, already lordship I have clarified on the UGC, in my affidavit, my lord, that 3.11. This point I need to read again, my lord. Roman 6, page 25.
Yeah.
The period of time taken by the candidates to acquire MPhil or the PhD degree shall not be considered as teaching research experience for appointment to the position or clause. My lord, it is there. But in UGC notification 18.7.18, there is a simultaneously, that what is not the other. Who to clarify on this point? The UGC authority will clarify this point, my lord. Here said that the period regarding simultaneously, this question is not before in page 25, this on this clause. That is clarified by the UGC in their notification, my lord. Which I have in my affidavit of opposition, annexure 1, I have enclosed this one. The UGC is the only party to clear this point, my lord. By simultaneously, if the teaching experience acquired by any candidate, whether it is acceptable or not.
Okay, then let us
Absolutely, my lord.
My lord, I don't have any objection, but the UGC is only a formal party. I don't have any grievance. I don't have any claim against the UGC.
That's why I am telling that the
And if this honorable court, my lord, during the midst of the proceeding, my lord, feels that UGC should be here, my lord, then, my lord, may direct to
as updated by 3.11.
my lord, that is why, my lord, my affidavit in opposition regarding that 3.11, that active service, what Black Law Dictionary says, my lord. These 3 pages, my lord, may I, my lord, take your lordship to my affidavit in reply. Only 3 paragraphs, my lord.
My lord, my
if
I have not yet completed my lord. Net is supposed to list. Yes.
Yes, but it's your
my lord, my affidavit
page number.
page number 86, my lord, onwards. First 85 minutes.
Correct,
Yes.
Page 85. Paragraph 8, my lord. Clause regarding clause 3.11, my lord, of the UGC regulation. A, B, C, we can skip, my lord. My lord, D. Next page, page 86. D for Delhi. Down below. That the certificate dated 7/9/23 of the respondent number 7. I have already shown that annexure to her affidavit in opposition, my lord, shows that she is a PhD research scholar who has been engaged to take classes since 1/9/2022 till the issuance date of the said certificate. However, her date of eligibility for assistant professor is with effect from 28/10/2022, much later than 1/9/2022. As per office memorandum, clause 8, my lord, she will have to be first UGC norms holder, then, my lord, that teaching job, my lord. But this date of effect is 28/10/2022, but the certificate indicates that her teaching experience from 1/9/2022. Her norms, my lord, from October, but her teaching experience is from September, as per this teaching experience certificate, which is reflected in her net certificate dated 29/11/2022 as annexed in next page, my lord, Annexure 3 in series to her aforesaid affidavit in opposition. Now, para E. That the government of Assam OM dated 24/1/2022, Annexure 9 to the writ petition, inter alia provides, in addition to the specific provision regarding the period of time taken, in the clause number 6 of the eligibility qualification thereof, in connection with the teaching experience in clause number 8 in the last portion of the said OM, that the service shall be after acquiring UGC norms. So she acquired UGC norm in October 2022, but her teaching experience, as per that certificate, Millard, it is from September 2020. Now F is important, Millard. That as per the Black's Law Dictionary and also other dictionaries in this regard, the word service means employment in one of the offices, departments, or agencies of the government, whereas in the instant matter, the respondent 7 has not been selected or appointed as per the existing laws of the land, including the Bodoland University Act of 2009, particularly Section 18F, 29C, 29D thereof. And no NOC has also been furnished by her in this regard, in tune with the Rule 24 of the Assam College Employees Provincialization Rules 2010, as well as the prevailing laws of the land in this regard. There is no selection process, no appointment process, Millard, as per this Bodoland University Act. And no NOC has been, Millard, submitted by the private respondent number 7, as per Rule 24 of Assam College Employees Rules, Millard, 2010. Now, next parameter. Furthermore, it is humbly stated that the words active service, it is important, Millard, that simultaneously word interwoven with this active service. The service word has been already explained in the Black's Law Dictionary, Miller referring that dictionary. The words active service in the clause number 3.11 of the aforesaid UGC regulation of 2018 to be read with the clause number 15.1 thereof. Next page, Miller. As well as the aforementioned UGC guidelines regarding junior research fellowship clearly make it impossible in the eyes of law for a candidate, for that matter, even for a service holder candidate pursuing PhD course, to spare more than 10 hours in a week for activities beyond research activities, that is, in the arena of relevant teaching activities, that too with the consent of the guide, head of the department, for 40 hours a week, which is mandatorily required under the clause number 15.1 of the aforesaid UGC regulations of 2008. Now, these contents of these paragraphs, Miller, also reflected in the division bench judgment. It is well nigh impossible for a research scholar to pursue, Miller, teaching, Miller, active service, Miller, as a teacher, Miller, while pursuing PhD, Miller. 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 Miller.
Or is it a data or
7 minutes.
then they want number 4, 5, 6,
4, 5,
yeah, 4,
1 and 2.
1, yes, you. That's number 8.
4,
4, 5, and 6. 4, 5.
Mr. Deka, Burnett, 7. It's a set. PC. Okay, right, it's part. And ordered with the date. There is a record. So it's taking to the sub. Both the part. Or that part. Why did that? by the third with it.
My lord, this is standing council is here, my lord.
Sir,
Yes, someone.
additionally, the serve after effective service by the concept by place the matter
In September.
place the matter is parted.
Until have no look. 122 my lord. 22 September, my lord. 22nd. Obliged, most obliged.
Lordship. I just.
Will be paid.
Will be paid.
When?
From next quarter, it is perhaps paid quarterly. So next quarter, they will get the 50%. And
Quarterly or quarterly or monthly?
No, it is already, the High Court had ordered, my lord, to pay monthly. There is an order.
I don't know, I'm told that it is paid quarterly. So quarterly,
But there is an order for pay provisional monthly.
Order dated?
You can,
quarterly, normally provisional pension is not paid monthly. They 3 month wise they pay. Provisional pension. Is not pension, regular pension.
So if there is a certain.
yes, my lord, I am searching the date. There is an order to pay provision pension month. Passed by Honorable Justice, you can,
Pardon?
passed by Justice, you can, date order.
In every month, yes, order dated 10/6/2020.
Also, the directives are pay monthly.
Why further direction? The direction there. We have to get it.
Because in the previous month, I'm told that 3 month payment together has been made. So, Lord, don't pay that.
I am under hardship, my lord, since the death of my husband, my
Or the or yes. What? Then the form of court. Or then that. Or seven. Getting served in order published or on website 5 and also include the order dated 10/24. The provision pension is paid at the rate of 50% per at the rate of 50% in every month, every regular. And the order of court has already it's a third, third, right, every mention
Provisional.
right as for in the area area
Lordship.
area within of
2 months, but
7 days.
it will take some time.
period of 2 weeks from today.
Lot.
Then the method for right here on
Month. Obligement.
So I am appearing for 4 and 5 yellow. 4 and 5 for college authority yellow. I'm not feeling well today.
pardon
Not feeling well today yellow.
you are not
Any day yellow. Next week, any
You
day.
should have told me in the morning, my lord. I think my lord, I should conclude, you will conclude later on, my any day. I'm sitting for morning.
it's correct.
Otherwise, this matter will be argued by Mr. TJ Monte, senior counsel. So I'll assist you.
Oh.
Mr.
Next day, DJ Mount.
TJ Monte. Sorry, आपने
Or that
This is not done, my lord. This is from morning. I've been sitting, my lord. It's all that he's ill. He would have taken time in the morning. Last occasion also he took time. I think last occasion, yeah, last 2 occasions, college authority took time. No, next week, you know.
And
The instance of the college authority, you lot can imagine.
college of in us
Like happened.
of return by and as no further
Yes. Well, keep it. Well, instead of 5th, can it be a 6th or 7th? My friend has got some problem. 6th. Yeah. 9th.
In this case, on last occasion, Malad has asked to bring some certain instruction, Malad. For that, Malad, I need some time, at least weeks time, Malad.
what happens in this matter? My lord petitioner was serving as he's the senior most professor of Cotton University, and he was appointed as a pro vice chancellor pursuant to a cabinet decision wherein 5 years have been extended for the senior professors. And it is applicable to engineering colleges, medical colleges, applicable to entire state of Assam, my lord. Pursuant to that, he is continuing, but I have filed an additional affidavit. Subsequently, I have been appointed as a Vice Chancellor of Pokrajhar University. Lordship. So my claim is that for a period of certain period I have mentioned in the additional affidavit, the payment be made for that period, because since they have utilized my services and it is on recorded, I was in duty, your lordship, on duty in the Cotton University.
But the duration
The duration I'll be stating, your lordship.
The 12th of November 2020.
Yes, December 2024 to 24/7/2025. Subsequently, I have tendered my resignation and I have joined my duties as a first Vice Chancellor of Pokrajhar University. So for that period, entire period I have received the previous period. For that period, since I'm entitled to the benefit, my lord, it may be given.
No, that is the thing, my lord. Actually, our stand is that the petitioner already retired, my lord. And it is an admitted fact that on attaining age of 60 years, the petitioner has retired. Thereafter, the petitioner was re-engaged, my lord. Now, after, my lord, there is a dispute that after retirement, whether she will come under Assam, state of Assam, or it will directly come the Cotton University, my lord. I have spoke to the authority, my lord, that whether they can pay for that period regarding when she was working, my lord. The petitioner was working. My lord, kindly give 2 weeks time, my lord. Because this will all have, the department has to talk to the finance department also, my lord, regarding whether the payment can be made or not.
Another aspect, my lord, is since there was an extension after 31st of March 2024, the government had extended, my lord, by a ex post facto order in July 2024. That extension order was withdrawn on 11th of November 2024. The status quo order passed was on 13th of November. So that issue is also there. So after the withdrawal, the status quo is there.
Lordship, may kindly see that submission my learned friend is making again and again. But I have stated in my writ petition 5934, stated on which date I have received the impugn order and when I have challenged and when order status was passed. Lordship, may kindly have a look at page para 9, page 8 of writ petition 5934. Just have a look, your lordship. WPC 5934/2024.
page number.
Page number 8, para 9. This is a statement we have made on oath, your lordship. I'm an honest officer of the government of Assam, your lordship. Honest teacher in the education department, my lord. Lordship, that the petitioner begs to state that pursuant to the order dated 16/7/2024 and 17/7/2024, the petitioner has been discharging his duties and responsibilities as pro Vice Chancellor of Cotton University to the satisfaction of all concerned as on date, and while he was discharging his duties as such, to his utter shock and dismay, he came across the impugn office order dated 11/11/2024, issued by the Secretary of Government of Assam Higher Education Department, whereby the extension of the service up to the age of 65 years. In respect of the petitioner, by office order dated 17/7/2024, is hereby withdrawn with immediate effect. That impugn office order has been sent to the petitioner through WhatsApp on 11/11/2024 at 5:50 p.m. And your lordship, it is absolutely unknown why the impugn office order issued whereby extensions and so. Then your lordship, order of status quo was passed. Subsequently, your lordship, I have stated in the later writ petition under what circumstances the order was passed, my lord. When communicated para 20, WPC 6871. Para 20, my lord. Is 14 of 6871. Has the lordship got it? Page 14, WPC 6871. Para 20. That the petitioner makes to state that the respondent, after coming to know about the order dated 13/11/2024, wherein this honorable court have directed that status quo shall be maintained in favor of the petitioner, have curated an impugned intimation letter dated 12/11/2024, issued by the Registrar Cotton University, whereby the services of the petitioner have been withdrawn by the government with immediate effect, and is requested to complete the release formalities. The Honorable Court has passed the order dated 13/11/2024 at 2:15 p.m. and the said intimation letter has been handed over to the deponent on 13/11/2024 at 4:30 p.m. and the same was received by him. The letter dated 12/11/2024 was also sent to the petitioner via speed post on 13/11/2024 at 4:11 p.m., which was received by the son of the deponent on 19/11/2024. The entire exercise has been carried out in violation of Honorable Court's order dated 13/11/2024. And while Lordship Government extended my services pursuant to a cabinet decision applicable to the entire state of Assam, including engineering colleges, government colleges, and Lordship medical colleges, and it has been also been informed to medical college, my lord, it has been raised to 70 years. For professions of other institutes to 65 years, my lord. Now they are, Lordship, doubting my extension, my lord. I have worked till this month, my lord, wherein I have tendered my resignation till 24/7/2025. But 24/7, I have tendered my resignation to the Cotton University. Since I was offered with a government job by the government of Assam only, my lord. For that period, I'm entitled to salary, your lordship. Last time was they had taken. Short
Kindly 2 weeks may be given, Malad. In the meantime, I'll
I prefer short date, fixed date, my lord.
ask that, Malad. Higher education. Cotton India.
Yes.
On number 5, counting. Or 5. The test does part and done it. Weeks time obtain. Accordingly, provided that the system after 2 weeks.
Then on date be given. Weeks. Lordship, last chance be given to them. They are taking time
I'll
again
get
and
something.
again.
Deeply.
So in this case, my lord, a grade 3 employee, my lord, recovery that was calculated, and XR1 is the impugned order, my lord. After retirement, it was calculated and issued that letter 2022, and mistake was by them, my lord, is admittedly in the year 2010 itself, my lord. As your lordship kindly peruse annexure 1 page 17, my lord. Just first paragraph I am reading, my lord. In inviting a reference to your letter number so dated 25/8/21 regarding finalization of the pension case of Bhairav Chandra Das, retired senior assistant, and to state that pay of the incumbent as on 1/7/2010 recorded in the service book rupees 13,760 rupees, As such, his pay is to be fixed as on 1/1/2011 as dated 14,360 with grade pay 3,000.
You were referring to part
Page, my lord, 17, annexure 1.
third one.
Yes.
Okay. The other day, the question.
Yes, my lord, already printed.
Sharma, this information
Yes,
is available. No, no. You have been asked to go through the description of
Rafiq Masiful.
Yes.
I have also annexed this recent judgment, my lord. Recent judgment I have annexed here. After Rafiq Masi, it was split out, my lord. And 10 years, similar incident is also similar, my lord.
In terms of Rafiq Masi and Annexure 10, that is notification of government. So it may be disposed of, my lord. Yes. Because he has already retired, my lord. Retired on 29/2/2020.
Amount calculated by them, my lord, page, my lord, 23A is evident 2,81,870. And that mistake, what has been calculated by them, is perused, my lord, page 23. By whom that mistake was there? Page 22, annexure 6.
Part
Only one thing, Lord. Anything more than 1 lakh as people from the finances.
Yes.
Memorandum dated 14 June 2009. More than 1 lakh. That
post number
9.
department will do the needful.
Yes.
He's not representing the.
I am not representing. Yes.
No, no.
Anything the
Letter to the finance department.
refer that.
Yes. Yes, we will refer.
Sorry, it's just 100 for the
And one more thing, Lord. One more thing, Lord. Department expecting the was thereafter. Like,
so respondent number
and for the accounting, respondent number 5.
5. Minus 30 years.
Yes.
article that is letter dated 4/1/2020. Second annexure based audit report for Royal of and also direct waive the excess Royal 81,800, which was caused due to wrong that by the then account and effective on 1/7. And thereafter, upon release of the petitioner, all the retirement and pensionary benefits which he is entitled after retirement on with you have not received the pensionary benefit.
No, my lord.
As there was a remedy. That's why we talk.
The task on it that was serving as president. It then it for service for 2020. Then after his retirement, the has submitted pencil paper. Then the same forwarded by the inspector school for the direct and account of account that and then the account officer of the center had declared the fine. The inspector of school on the ground that there was wrong date pay on 1/1/11 that posed by the then accountant inspector and also the matter was directed by the for waiving recovered after his retirement and that amount was not covered. But the authorities neither waive the recovery of extra nor fixed pay nor refixed pay and it determined that pension benefit take one and referring to the court.
AIR Supreme Court, that will be there. Supreme Court 215, Annex 9, page 26. It was recent.
The conduct and other from us avoid the etc. Why the authority direct at the one eight of 12 and the and web dated on the basis of the government of the dated 7 2020 and also the basis of another the stick of period SPR 606 6 submits the has already declared under the amount of excess royal cannot be covered from the pension benefit and as such the benefit allowed the allowed by the to waive the excess royal amount and is that
Sometime maybe.
it does not answer you sort that part that It's a like the portrait uh, will take up the according to clause number 7. 9. Clause 9 of the of the this is not notification. Office memorandum note dated 14 June 2019. Basically, clause number 9. That is divided clause 9 that when the with the above 1 lakh, 1 lakh, then express approval of the price or having heard of the part of and also consider the of topic and of the and OM and the certificate also the of party it's here that or it have not filed their it is uh, the basic fact in this not dispute, not in dispute. Petitioner declared separate president that on the and after his retirement up and forwarded by the inspector of the Bakara, the direct and then of the account officer of the is but the account officer of the account is based on reports of account of its date rate on 1/1/2023 and it is categorically stated by the petitioner that the same the document was by the accountant and inspector of school developer. It will be sent by the it is to be noted here that on the uh, the, the government of Assam has not or the certificate there is when required by the employer pharmacy recovery from employee service for group and service. Number four is retired employees or employees are retired in 1 year of the order of property. Number three, property employees when the exit has made for a period in excess of 5 years. The order of property is to perform property case where an employee has not required service of a buyer and has paid accordingly, even though he has right where work within the or five. Any other case where the court arrived at the so that property made from the employee. But if that but if made from the employee in or hard and arbitrary such an extent as to outweigh with the balance of employer like right and in the present case the petitioner service on 29/2020 thereafter later stated was was after almost years and appears that the over by about over one or one of the of stated that and as the later stated for one when appears to appear
If this aid is confirmed, that will remain not. Only the recovery part is what to be detected. Pay scale has to be as per his entitlement. The recovery part in this letter we have stated what is this entitlement. That will remain.
for the recovery part is concerned appears after the public and the then Thomas then under such circumstances the letter dated the letter dated for 1/2020 party concerned liable to be prepared and according to the same prepared now the petitioner shall file oil file
Yes.
Along with the
We have already filed. All petitions are pending up to 25.
the taking of the party record and the way the letter way for of by directing the resolution for this way the excess royal made by the the previous order. And also release the special in a period of
Lordship, as per this category, title, as per this title. So this
within a period of 4 weeks from the 4 weeks. As per his undertaking.
My lord, 2 months may be guaranteed, my lord. 2 months may be guaranteed. And moreover, petitioner representation with the certified copy of this order is required to the inspector of it. Yes.
And plus the order
And same shall be disposed of, my lord. Same shall be disposed of within a period of
already ready. 4 weeks.
4 of last. Aliveness.
The matter has become infructuous, since the prayer is regarding the abandonment of selection process, cancellation of selection process. It is regarding selection to the post of associate professor in
Not
Guwahati University.
It's not infructuous, my lord. They can appoint me. They can appoint me, my lord.
They have appointed.
They can appoint me. There is nothing stopping them because they say that the matter has taken some time to be decided. My lord, if I can take your lordship over the brief facts. I'm permitted, my lord. Here. My lord, this writ petition was occasioned, my lord, because respondent number 6, her name was recommended. Respondent number 6. My lord, the cost title is at page 3. Here. Dr. Bhia, Assistant Professor, National Institute of Rural Development and Panchayati Raj, Northeastern Regional Center. Lordship says that. My lord, I have assailed the recommendation of the selection committee, my lord. My challenge is based under paragraph number 26 and paragraph number 27 at page 10. Lordship says that the apprehension of the petitioner regarding bias with a preconceived plan was further fortified when the petitioner got to know that Professor Anuradha Datta, the subject matter expert of the interview board conducting the interview, had co-edited 2 books titled Women and Peace, Chapters from Northeast India in 2 volumes, along with Dr. Ratna Bhuya in the year 2008 by way of paid publication. My lord, Professor Anuradha Datta is the respondent number 4, who was a subject matter expert. And my lord, Ratna Bhuya is the recommended candidate. Then my lord will kindly come to paragraph number 27, same page, my lord. That the petitioner further fortifies her claim of bias in the process of recruitment to the post of women's studies, inasmuch as Sri Bhupen Sharma was also instituted as a member of the selection committee without having any expertise in the field of women and gender-related studies. Sri Bhupen Sharma is a professor in the Department of Ethnicity, Peace and Conflict with the Omyo Kumar Das Institute of Social Change and Development, and has no relation to the field of women's studies under which the said process of selection, the said professor was held. It is also noteworthy to point out that before this honorable court, that Dr. Ratna Bhuya, being the beneficiary of the selection process, had worked in Omyo Kumar Das Institute of Social Change and Development in close quarters with Sri Bhupen Sharma, and Bhupen Sharma was roped in to benefit only one candidate. My lord, that was our submission, that both the subject matter experts had close proximity to the recommended candidate at respondent number 6. These were our submissions, my lord. Then, my lord, your lordship will kindly see the order at 5/8/2021. 8/2/2021, my lord. This was the order where an order of status quo was granted. Page 3, my lord. The second last paragraph. This matter for motion on so and so. Till then, that is 11/2.
Order dated?
My lord, 8/2/2021. 8/2/2021. List this matter for motion on so and so. Till then, that is 11/2/2021, the parties to this proceeding shall maintain status quo as on today with regard to the post of Associate Professor in Women's Studies at Guwahati University as advertised by so and so. My lord, so as of now, the post of Associate Professor in Women's Studies is vacant pursuant to this stay order, which was passed in the month of February in 2021. Now, my lord. Now, my lord will kindly come to page 70. Page 70, my lord. This is an affidavit which was filed by the Guwahati University, respondent 1, 2, and 3. My lord, before I take your lordship the contents, your lordship will kindly see the date of the affidavit, which is on 17th February 2025.
Page number?
Page number 75.
Yes.
This affidavit was filed on 17th of February 2025, not almost, my lord, after 4 years. Now, my lord will kindly come to page 73, paragraph number 5. These are the statements, my lord, paragraph number 26 and 27, where we stated that the subject matter expert had close proximity to the recommended candidate. There, with regard to the statements made in paragraph number so and so, 26 and 27 is also there, my lord. While putting the petitioner to the strict proof thereof and reiterating the statements made herein before, it is humbly stated by this deponent that it is also not acceptable in the context of the factual situation as regards the aforementioned selection process, the post of Associate Professor in Women's Studies, Guwahati University, that process of interview is vitiated by the principle of bias, and that the constitution of the selection committee itself was tailor-made for the respondent number 6. It is respectfully pointed out in the instant matter that the writ petitioner herself took part in the selection process without any objection till the completion of the selection process, and as such, the writ petitioner now cannot turn around to question, challenge the very said selection process unless there is a flagrant violation of statutory provision in the state process. My lord, fair enough. This is a submission that I've rebutted on merit. Now, immediately thereafter, my lord, when this affidavit was filed, your lordship will kindly come to the order dated 5/3/2025. Now, this matter was listed for the first time in 4 years. 5/3/2025.
Yes.
Now, your lordship will see the second paragraph at page 2. Mr. So-and-so, learned counsel representing the university, submits that the university is intending to abandon the entire selection process and they'll initiate fresh selection process. However, due to the operation of the interim order of status quo, the Executive Council of the Guwahati University has not been able to take a concrete decision. In view of the aforesaid, it is provided that through the status quo as granted shall continue to operate. However, the same will not debar the respondent university to take a fresh decision as proposed regarding abandonment of the process, my lord. However, such decision be brought on record by way of an affidavit. Your lordship will see that the affidavit had rebutted the claim of the writ petition on merits, but a different submission was made before the court immediately 10 days thereafter. Now, my lord, pursuant to the order dated 5/3/2025, there was another affidavit which was filed, my lord, which starts at page 76. Guwahati University, my lord. This was filed, my lord, on April, in the month of April 2025. Your lordship has got.
Okay.
Yes, my lord will kindly come to page 78. Paragraph number 4. That this deponent respectfully begs to state that the instant matter revolving around the proposed fresh selection process regarding the earlier advertised post of Associate Professor in the Department of Women's Studies of the Guwahati University has been duly placed before the recent meeting of the Executive Council of the University on 21/3/2025, and the said meeting, after discussing the matter in detail, within bracket, in the context of the aforementioned order dated 5/3/2025 as passed by this honorable court in the said writ petition, has taken the decision inter alia for initiating fresh election process as regards the aforementioned post of associate professor in the Department of Women's Studies, also deciding therein that the said decision would be carried out only after this Honorable High Court passes order to the effect of allowing to go ahead with the fresh selection process. My lord, the liberty was already granted by this Honorable Court by the order dated 5/3/2025 that the interim order, which is operating at that point in time, will not debar the authorities from passing any order passed by the Executive Council regarding the cancellation of the process. It has not yet been done as of now, and subsequent and pursuant to the order dated 5/3/2025, the Guwahati University has pleaded paragraph number 4 before this Honorable that they have taken a decision. That decision was already conveyed before the Honorable Court. Now, my submission, my lord, is a very limited submission. The fact is, for 4 years, the post of associate professor was kept vacant. There was no stay vacating application which was prepared by the Guwahati University citing urgency. Now they have come at this point stating that since the post has been kept vacant, they need to advertise it afresh. My submission, my lord, is that since they have decided to abandon the process, since the respondent number 4 and 5 are yet to be represented in the matter, they have not filed any rejoinder, any affidavit contesting the matter, my lord, I can be appointed. It will be in the interest of the university, it will be in the interest of time, and it will be in the interest of expenditure which the university is going to incur. Or subsequently finalize the matter, my lord, or allow the petition, because since what they have done effectively is they've stated something else in writing and they've submitted an completely a different aspect before this Honorable Court. Now, even pursuant to 5/3/2025, they have not come clean, my lord. The university has said we have taken a decision which is already reflected in 5/3/2025. Now, 5/3/2025 had directed the authorities to come up with the order, a specific order, a resolution that is yet to be put on record, my lord. That is my submission, my lord. My claim was based on the fact that the selection process is vitiated because of the element of bias that has not been addressed to by the Guwahati University, that has not been refuted by respondent number 4 and 5, that has not been refuted by respondent number 6. Then they can allow the petition and appoint me as of now, as of tomorrow, my lord. I'll be glad to join. I have family issues. My residence is in Guwahati, my lord. There is no impairment of me joining the university. If they say that time is of the essence, then appointing me would be in their best interest, unless there is some other consideration at play, my lord. That is my only submission.
Now, where are
My lord?
now where are
My lord, as I understand, my lord, I'm working as a professor in BTC, but I'm willing to come back to the post of associate professor in Guwahati University. In Borolan University, my lord. In Borolan University. But I'm willing to come back, my lord. Regarding my pay protection, that's a separate matter which will be argued before the court. But today, as of now, I can submit before oath, my lord, that I'm willing to come back to the university to the post of associate professor. Your lordship will see the discrepancy in the affidavit and the order dated 5/3/2025, my lord. That is my only submission, my lord. We are not arguing on merits as of now.
what the order? On one hand, it is that it's
Shall be maintained.
for it. On the other hand, it says
Yes. However, yes.
take a press.
Yes. The aspect is that the seat will be kept vacant. But in the meanwhile, while the seat is kept vacant, you can pass any orders regarding a fresh advertisement if the Executive Council so deemed it right. That was submitted on 5/3/2025 before the court, orally. The order of 8/2/2021 is not an interim order, it was an order of status quo. It meant the same thing, but it ideally meant that the seat will be kept vacant, the post is kept vacant. For that aspect was not given as an impairment for the authorities to pass an order. Then the affidavit which is at page 76 comes to be filed before this court, stating the same thing that we have decided. But the Honorable Court's order is the one which is stopping them from passing an order. The university has gone round in circles, my lord, because the submission which was made and the order directive of this Honorable Court was not complied with by the university for passing an order. My submission is since the matter has taken 4 years, which according to them has affected the student community, my lord, they'll direct me to be appointed, my lord. I'll join.
Officers were served out of
All of them, my lord. All of yes, my lord. Everyone. In fact, my senior friend, Mr. M. Das, appears for respondent number 5 and for respondent number 6. They have no instructions from the client. They've abandoned the matter. And there is no stay vacating application which has been filed as of yet for 4 years, my lord. And now the student interest has been thought of by the Guwahati University. Surprising.
Yes.
My lord, first of all, my lord, stay that the task order has been passed in 2021. And my learned friend, my lord, takes steps on the respondents in 2025 after a long 4 years.
Pardon?
In 21, status quo order has been passed and steps have been taken after a long 4 years in 2025 on the respondents.
The Lawazima court, my lord, we had taken steps, the steps are not completed. But Guwahati University was served with a copy. They could have approached, my lord. Respondent number 6 has entered it here. And I'm submitting on oath. He does not have instructions. My senior friend, Mr. M. Das. Respondent number 6, my senior Mr. K. N. Chaudhary also appeared. So that submission may not be 45, my lord.
I think, my lord, nobody is interested, but my lord, the writ petitioner has already joined in the professor's post in Borderland University, and it is associate professor post. Anyway, my lord, since my lord, the writ petitioner is interested to,
Cannot be the ground.
my lord, and I take your lordship to that order dated 5/3/2025. This honorable court's order.
That's right, but
My lord.
that's why I'm pointing it out. That on the one hand, it is stated that the chief granted have nothing to operate.
My lord.
And on the other hand, granted liberty to you make a test.
My lord. So, my lord, there are two parts. One, taking decision, and another, executing that decision, issuing fresh advertisement and such things. So, decision has been taken by the Executive Council, my lord. My lord, to that effect, my lord, I have, my lord, after that order dated 5/3/2025, I have, my lord, filed additional affidavit on 8/4/2025. That paragraph 4, my lord, page 78. May I read that para again, my lord? In March, that order was passed. In April, this affidavit has been passed. That paragraph 4, page 78. This deponent respectfully begs to state that instant matter revolving around the proposed fresh selection process regarding the earlier advertised post of associate professor in the Department of Women Studies of the Guwahati University has been duly placed before the recent meeting of the Executive Council of the University on 21/3/2025. It is after that order, my lord. And the said meeting, after discussing the matter in details in the context of the aforementioned order dated 5/3/2025, as passed by this honorable court in the said writ petition, has taken the decision inter alia for initiating fresh selection process as regards the aforementioned post of associate professor in the Department of Women Studies, also deciding here therein that the said decision, it is important, my lord. Decision has been taken, my lord. Also deciding therein that the said decision would be carried out only after this honorable High Court passes order to the effect for allowing to go ahead with a fresh selection process by the Guwahati University authorities in this regard. So, my lord, the Executive Council's, my lord, resolution. But may I place that resolution? Resolution number 13, Miller. May I read, Miller? High Court matter regarding the post of Associate Professor in the Department of Women Studies. The matter pertains to a post of Associate Professor in the Department of Women Studies, Guwahati University, advertised by the advertised number so-and-so dated 2/6/2020. The selection committee meeting of the said post was held on 21/1/2021. The selection committee recommended Dr. Ratna Bhuya, private respondent Miller, for appointment. Accordingly, selection committee's recommendation was accepted in the Executive Council in its meeting dated 23/1/2021. The appointment letter was also issued to Dr. Bhuya via the letter dated so-and-so. Meanwhile, Dr. Sanghamitra Choudhury, the writ petitioner Miller, challenged the selection of Dr. Ratna Bhuya to the post of Associate Professor, Department of Women Studies, Guwahati University, before the Honorable Guwahati High Court in case number so-and-so versus so-and-so. The Honorable Court, by an order dated 8/2/2021, was pleased to direct a status quo in the matter if Ratna Bhuya has not joined the department. In a recent development, the Honorable Guwahati High Court, by its order dated 5/3/2025, in the said case has ordered as below. Miller, that is quoted, Miller. List the matter again on 9/4/2025. Earlier interim order shall continue to the extent indicated herein above, that is, status quo order shall not operate as a bar to take a decision by the Executive Council as submitted by so-and-so. In view of the above, the University Authority now could proceed with fresh selection process regarding the earlier advertised post of Associate Professor in the Department of Women Studies, Guwahati University, as per the said order dated 5/3/2025. The matter is placed before the Council for approval. The Council members were of the view that the selection procedure for the said post, which has been challenged by Dr. Sanghamitra Choudhury, may not be cancelled until the final verdict of the Honorable Court is announced, because there remains a probability that Dr. Ratna Bhuya, who had been selected through the earlier process and was issued an appointment letter, may challenge the decision in that case. Since the next hearing of the case is on 9th April 2025, the members recommended that the next page, that the university may wait for the final verdict of the court. Dr. So-and-so was of the view that Dr. Ratna Bhuya may be communicated beforehand for her consent if the university proceeds to resign the earlier selection process and goes for fresh selection process for the post. The chairman was of the view that the university should submit the affidavit to the Honorable Court as advised by the Standing Council and wait for the final verdict of the Honorable Court in the ongoing litigation before the fresh selection process is taken up, which the Council agreed to. The following resolution was adopted in the matter. Resolution number so-and-so. Resolved that the university shall submit an affidavit to the Honorable High Court to the effect that the entire selection process pertaining to the post of Associate Professor in the Department of Women Studies, Guwahati University, advertised by the advertised number so-and-so dated 2/6/2020, be abandoned and fresh selection process for the same post be initiated. Also resolved that the execution of the action stated in the affidavit be held up until the final verdict of the Honorable Court is received in its favor. My Lord, this is dated 21/3/2025. Thereafter, my Lord, this affidavit has been filed, my Lord, in April, my Lord, and subsequent to this decision, my Lord, on 30/5/2025, this resolution has been confirmed in the next meeting.
Inconsistencies are there in this order that 5.
My Lord.
Not it.
Yes, my Lord. My Lord, on one hand, my Lord, Guwahati University authorities is directed to go ahead with the my Lord, abandoning process and initiating fresh selection process. But on the other hand, that status quo order, it's like Damocles sword hanging on the head of the executive council. So that is why, my lord, executive council,
You cannot proceed with them.
my lord,
Further, you cannot proceed with them.
no, my lord. First part is over. The decision has been taken, but the second part, execution, taking action, that means, my lord, advertising the post. My lord, due to that, this status quo order, that cannot be, my lord, done. My lord. Otherwise, it would be contentious for the university authorities. My lord. So we are in a standstill position. The writ petitioner,
The respondent number 2, 5, and 6. This not contest this petition. Then what to this order of what to allow.
my lord, don't know, my lord, but these private respondents are possibly not interested in this proceeding. And the prayers are twofold. One, for cancellation of the selection process, and two, for appointment of the writ petitioner. My lord, that cannot be, my lord. Since, my lord, the select,
Pairs may be made, but court can own the pair.
my lord,
Then one pair is already there.
my lord,
Appoint her.
my lord. But, my lord, that selection process, only one name has been suggested, my lord, nominated, that private respondent number 6, my lord. That was forwarded as per FRBM Act, also, my lord. My lord, only for one post, my lord, only one name. There cannot be any waiting list or other things. So, my lord, that one name, private respondent number 6, that has been forwarded by the selection committee to the.
That
Then, my lord, entire selection process goes, my lord. Then entire selection process goes, my lord. As per this, in tune with this FRBM Act. Possibly section 7.
that act is available.
No, my lord, that FRBM Act, I don't have that. 9.
Yes.
My lord, in my humble submission, subject to your lordship.
Said that that recommending that how get how to appoint. Yeah.
My lord, my submission here, my lord, is that respondent number 6 was arrayed as a private respondent solely because her name was recommended for final appointment as an associate professor. Now, if your lordship allows this writ petition in the absence of any averment from the respondent, I step into her shoes, my lord. I step into her shoes. That recommendation will be set aside because we have assailed the recommendation itself on the ground of bias. My lord, I'm not aware of that. I'm actually not aware of that, my lord. If my friend, if I can maybe allowed to go through it.
That is the position nowadays.
Yes.
There not any waiting.
Yes.
And the writ petitioner is not the second position holder or third position holder. Only one post, one name. If that goes, my lord, everything goes.
Let us keep the matter part.
My lord.
For that act.
FRBM Act, my lord.
Yes, my lord, I'll go through. No, because, my lord, I am willing to come down a post and be posted in Guwahati as an associate professor. This is my submission on oath. There is no dispute to that, my lord.
Or else they have to
Understand, my lord.
My lord, if your lordship gives me only 5 minutes, my lord, that FRBM Act is with me, my lord, in my locker, my lord. Then after 5 minutes, my lord, the matter may be taken up. My lord, I have that book in my locker, my lord.
I'll also need to go through, my lord. Yes, yes, my lord.
My lord.
Right.
9. Wednesday.
Thursday. The Wednesday DTO.
Part of- part-
UGC.
Lordship Y.N. Mohanto on behalf of
Your name?
Lordship Y.N. Mohanto.
What?
7.
Party part? This matter order hearing on 7.
Wednesday. Most of life.
Next matter.
Here we lost. This is a more than decade-old contempt petition here, Lordship. I'm sorry for Lordship, my lord, the outside, my lord. The issue involved and matter in issue, my lord. Lordship has an stand taken at present in the contempt petition, my lord. The Lordship has given a sincere report and present after present hearing, my lord, analysis all relevant facts, scrutinize all documents, passed a judgment on notice on 16/7/25. It could be a more amplified manner if you kindly peruse Lordship your Lordship judgment manner paragraph 15, paragraph 15. Look. Paragraph 15, page 24. Order of division bench. Your Lordship relied and discussed the division bench order.
Paragraph number?
Paragraph number 15, 1-5. May I read order?
Yes.
It is also not disputed that before the aforesaid communication, the government had stopped the salary of the petitioner. They are being left with no option. The petitioner, with the sum of the similarity situated features of Nazira subdivision, had approached this court for redressal for the grievance by filing petition number WPC 840 of 2007 and WPC 522 of 2007 for issuing direction for payment of salary and allowances, and a division bench of this court, fight order dated 19/5/2010, had directed the respondent number 2 to 7 to the said the petition to pay area dues with effect from 1 to 12 to 30 April. That shall be paid by the government concerned in all pieces within 1 month from the date of order, that is 19/5/10, and also directed the government and officers shall ensure payment of monthly salary on 15th of each succeeding month. What my land, respectful submitting your lordship, my lord, did WBC 840/2007 and 520/2007. Present petitioner also the petitioner of that WBC. The petitioner of your lordship in the contempt petition, they were the petitioner in both the cases. I submit, brother, 840. (840) and 523.
May I please, my lord? My lord, in this matter, we have filed our affidavit in opposition today, my lord. We have served them a copy today, my lord. Perhaps, my lord? Exactly, my lord. It's a contempt petition, and my lord, we had been directed on the last occasion, if your lordship sees the order, that from the 13, my lord, petitioners, my lord, what is the current status? So that affidavit has been brought on record, my lord, and we have served them a copy today.
Yes, served the copy, my lord. I have received, my lord. So for stand taken, my lord, that also has been discussed by your lordship in this.
So, my lord, let the
contempt proceeding,
let the contempt.
There cannot be any action of pleading between the parties to ascertain the judgment already passed. If someone is aggrieved, my lord, he can go for appeal and revision, my lord. There was attend finality, my lord. And honorable appeals could have said, doctrine of finality has to be followed in a strict manner in strict legal sense, my lord. Last more than decade, my lord, I am 1% retired, my lord. Their future prospect and family prospect schools is already curtailed, my lord.
My lord,
so it is already covered, my lord. What has stand taken in the EA, my lord, that has been discussed by your lordship.
The honorable court had directed us specifically, my lord, to get the status of the current petitioners, my lord. There are 13 petitioners in this case, my lord. we have accordingly brought on record, my lord, the status of the 13 petitioners, and out of which, my lord, the affidavit is not come on record, my lord. Out of which 5 have already been accommodated. That means they have waived their right to get it, my lord, because the 5 they have waived, my lord.
They do not come under the purview of the cabinet memo number.
My lord, can the affidavit come, my lord, on record? Can the affidavit let the my lord lordship pleases that
Lordship, I may be hard, your lordship feel my lord, I will obey your lordship. my
let
lord.
the affidavit come on record, my
Because,
lord,
my
a
lord,
date may be given, my lord.
there cannot be excessive pleading. To assert the genuineness of the order already passed. my lord.
My lord, that they should have objected.
That direction
That they
was, my
should have
lord,
objected on the day the court directed us, my lord.
step
Lordship will
taken
kindly see the
towards the contents of the order. Not to hesitate against the merit of the case, my lord. Direction given by the court, steps taken towards the compliance of the order. Not to hesitate the order already passed.
that they should have done it the day.
So I may be hard, lordship.
My lord, that day also, my lord. So, my lord, will kindly bring on record, my lord.
What is the question of filing of affidavit in
Additional affidavit, my lord, bringing on record the status, my lord. That was has been given, my lord. I'll kindly email.
Lordship has answered in paragraph 20, my lord. Of your lordship as a lordship judgment, my lord. Page 27, paragraph 20, lordship already discussed and giving sincere report that has been appreciated by the all, my lord. These discharge cases only my constant public gaze, my lord. Because last 11 years this contempt is pending, lord. Actions of pleading, action. We also compel, my lord, to answer, my lord. So there cannot be actions of pleading, my lord.
My lord, that they should have objected at that point of time when the court directed them to bring this current status. And the people many of them have retired also, my lord, and some of them had been accommodated. So when they have been accommodated, my lord,
5 PT petitioner
my lord,
out of
5
15,
people.
my lord. One
No, that is why,
retired,
my lord, this affidavit will be required for the proper, my lord. Let the affidavit come on record, my lord. Then, my lord, let him make the submission then.
I
Once
may
it-
be hard, lordship. If
Yes,
your
my lord,
lordship direct me, my lord, definitely I will obey.
Obviously, my lord, my lord, he has the right to be heard.
Your lordship, my lord, there
Only thing, my lord, the record, it should come on the
who
record.
has given the appointment, my lord? The all cure formula that teachers and accommodated teachers.
My lord, let the affidavit come on record, then he can argue, my lord, because then only he can argue. Lordship has not got the
Lordship
copy.
kindly page
we have
paragraph
filed-
20, my lord. Lordship order paragraph 20, my lord, page 27, my lord.
I have gone through it.
Lordship will have it on some other day, my lord. That let the affidavit come on record, my lord. Lordship will see what the record says, my lord.
No, I am not
Because,
denying, my lord.
because the court has given.
They
Otherwise, we will
were-
not file this, my lord. Unless
they
we
were
will not
given
file this.
appointment of 5 persons.
You tell me what was the exact direction in the order dated 11/8/25.
I'll just check it up.
Whatever the other teachers, my lord. One is already retired, my lord, without single penny. Out of 13, my lord. Lordship already deal the matter, my lord. So that is why I mean, give a lordship order, my lord. And the same petitioners, the lordship relied upon. And if your lordship kindly page 9.2, lordship, paragraph 9.2.
Lordship will have it after some time, my lord. I'll get the order, my lord. The current order, my lord. I'll just take it up. Because, my lord, we have filed this.
A week time granted
That is the previous order.
file their affidavit in
That is the previous order. That is previous order. Pursuant to that, my lord, there is one more order. The lordship sees the previous order. There, my lord, somewhere it is given, my lord, that we have to bring on record the current status of the petitioner. So that is why we have brought this, my lord, on record. On the last occasion, I was not able to file it because we did not get the adequate information.
after 11/8/2025, no order is there.
No, before, my lord, before. Prior to the previous order. Prior to the previous order, there were orders, my lord. Mr. R. Majumdar was previously appearing, my lord. He now no longer cannot appear, my lord. So that time, then, my lord, that particular instruction was asked to be brought in. Because that will be required, man. Some of them had been accommodated, man. Some of them had been accommodated. That particular statement had been made, man, at that point of time. So the court said that you get the current status of all
They
these
haven't
people.
come under the public
Once
cabinet.
the status is seen, we'll get to know what the status is. That is why this affidavit has been filed, man. I have prepared this, man. So let the affidavit come on record because as we have filed it today, it is not on record today. We have served them a copy also. So if it comes, my lord, then let him argue, my lord. He can argue his case then, my lord. Then we will also present our case, my lord. And whatever it is, my lord, whichever way it goes, my lord, is up to your lordship.
It is up to your lordship, my lord.
Then
My
have it next
only
week, next
humble
week, my
prayer for
lord.
you,
Next
lordship,
week, next week, my lord.
since lordship has already given a sincere report, discussion, analysis, and reach up to the depth of the cases, my lord, it may be recorded as part heard, my lord.
Can be taken on net.
Otherwise, my lord, the lordship is not required to giving a
My lord, part heard, why required, my lord? Why they want part heard, my lord? Have it on the next week, my lord. Fixed date, fixed date.
Why you
Fixed
objecting,
date. My lord, why he wants, my lord, part heard, my lord? He
Because
can
my
have it
lordship
fixed.
has
My lord will
already
give a fixed
discussed.
date. My lord will give a fixed date. Any day
Lordship has
fixed.
already discussed all.
Why does he want it part heard, my lord?
Lordship has already paid his document, discussed, my lord, passed the order.
No, my lord. My lord, there is no objection, my lord, but lordship will have it fixed, my lord. And then my lord will keep it part heard, my lord. As, then every case he'll, my lord, last time.
No, not every case. This is the only case, my lord. After 11 years, I'm submitting, my lord. After 11 years of content, my lord.
There are a lot of things going on in this case, my lord. Lordship will go through, my lord, lordship will come to know, my lord. And that's why we have been asked to file this.
My lord, maybe since lordship has already discussed, my interest is, my lord, lordship already discussed, my lord. Produce the all document.
Okay.
It's all the documents.
And for it's got 19 months.
Order of this file way and the thing not classified. Let's stop. Here. Part of
Make your lordship convenience, date may be fixed. Right.
whether your affidavit will say that that's already settled in the main case.
My lord, since my lord, the affidavit was asked that we were asked to bring on record the status, my lord. That also is a judicial order, my lord. So we have complied and we have got it, my lord. Thereafter, my lord, we'll take up the case, my lord.
That you have submitted that you will file an affidavit.
Affidavit regarding the status of the petitioners, my lord.
The direction already in the written. Unless you file review petition or appeal.
We'll
Can a sitting as contempt court, it can modify that order.
my lord, on the next occasion I'll address it, my lord. I'll address this issue.
Obliged.
The lordship kindly pass over for the timing. And the Khataniya was there, my lord, but he has to go on code number 2. Only he is on leg there.
Lordship. My simple prayer, Lordship. Here, this case is contempt is clearly made out. So, Lordship, they are rejected. So, I have already filed a fresh WBC. So, let them, this matter may be take with this fresh petitions, Lordship. Number is there. I have filed- This matter, Lordship, what happened?
What is the number of writ petition?
No, Lordship, this is a filing number. I have filing number, Lordship. Yesterday, I have filed. As because, Lordship, last occasions, they have submitted
The filing number.
Lordship 10886.
Dated
Dated, Lordship 28 25, Lordship. Lordship, let this matter maybe be taken on 27 or 26, Lordship. Along with Lordship.
So you come what is your objection?
My lord, I am not here in this case, my lord. So NJ Khataniya is there, my lord. But NJ Khataniya has to go on a code number 2, my lord. Probably he is on leg, my lord. After some time he will come here.
The counsel for the petitioner has tried to dismiss the matter on some other date.
Yes.
That is,
Yes, Lordship. What?
the meantime, he has already filed one late petition.
Lordship, one more submission, Lordship. This contempt petition arose, Lordship, this is writ petition, which was disposed.
Lordship, there was a direction is there pursuant to one notification, but they are now they are rejected. So that memorandum or notification did not consider. So that's why, Lordship, that disposed matter maybe take with this contempt matter, Lordship. That means one disposed matter and already one I have filed. Both matter maybe take this contempt matter, Lordship.
So, what is the subject matter of your writ petition?
Lordship, here what happened, Lordship, this is the provincialization of service of the present petitioner's, Lordship. He was initially approached before this honorable court in the year 2010, Lordship. And in the year 2010, this honorable court has been directed to this matter may be placed before this high power committee. And in the year 2015, this high power committee has been rejected and ultimately again approached before this honorable court. And honorable high court again set aside their view and remanded this matter to review and re-examine this matter. Again, they have rejected in different footings, Lordship, and ultimately last order of this writ petitions. This everything has been
Okay. The number of the writ petition is 4689 of 2020.
yes, sir.
Or I hope.
Yes.
Or- Also, definitely we have and the learning for the by with by number 1 to the page 6 that is page 20 and all the earlier rate for the 4, 8 and both the rate are required to take with the present record by the after 1 week.
No, Lordship, on 26, this is some urgency is there, Lordship. On 26, Lordship, some urgency is there as because petitioner is going to supernation and he is going to, he has already filed 7 number petitions before this honorable court and all the petition has been allowed. But what happened, Lordship, then whimsically, without any reason, so 26. Highly applies.
In this matter, compliance order has been passed in the contempt matter. And here, inspector of school, as this is Tezpur, is directed to take all necessary steps to provide pay and allowances in terms of provincialization of the services as affected by order dated 2/9/2013 with effect from 1/1/2013 till the date of his death, if any due, after proper verification of all the documents.
Earlier order is restored.
Yes.
Your Lordship, a copy may be furnished to us so that we can inquire.
Part that
JP Burwa.
JP and
Respondent number 4, Lord.
During the course of hearing, Sir Forma has produced an order passed by the director, passed by the number. That and some extent the order of this court passed in review number 166 of 2021 along with the number has already been complied with by restoring the order dated or respect of state order to extend the benefit of said provincialization order till the date of its death on 31/1/2020. The learned court of Contempt directed part a copy of the order and fix the matter after
Yeah, that may be fixed, Your Lordship.
the order complied.
Yes, we can say after inquiring with the party, a date may be fixed.
My lord, I am also appearing on behalf of SMT 60, who is representing respondent number 3. Yes.
The order for the part A and sub part
Deeply obliged, Your Lordship. My lord, by this, I am, my lord, of seeking for correction of the clerical error in the judgment dated 29/7/2025 in LA Appeal 1 of the 2025 past test number 4. Your Lordship, if I may take Your Lordship directly to page 28, Your Lordship, of my application.
paragraph number
28. 28. Paragraph number 7. My lord has it. My lord, it has been recorded as if I may read, my lord. In reply, Mr. Sharma submit that the appellant herein had now engaged advocate so and so to represent it before the learned reference court. However, my lord, in our submission, we have said that we had not engaged him, my lord. So instead of not, it has been reflected as now, my lord. So I only seek to substitute the word now to not, my lord. And also, my lord, also, my lord, if my lord come to page 23, my lord. Yes, my lord. My lord, have it. My lord, the respondent indicate here is there are 4 respondents, my lord. And the remaining respondent have been put in the column of the appellant, my lord. From here is shown as only 4 respondents. And the remaining respondent it has been reflected in the appellant portion, my lord. Whereas Apogrit is the sole appellant, and from appellant number 2 as indicated till 27, it should have been in the portion of the respondent, my lord. Only these 2 aspects we're seeking correction, my lord.
This first title is already available in the website.
Yes, my lord.
So there is mistake at the time of enter the data in the system at the time of filing of the petition. What is that?
T Marangar.
Learned for the applicant. And for part is
J-based Brewer.
J-based Brewer, learned opposite part. The interlocutor applicant. Applicant correct. Just the order dated learned the order dated 7, order dated
29/7.
5. Paragraph number 7 the reply that it has now engaged the by the reference for then that the submission was the appellant had not engaged appellant advocate transfer by the the and further, the council for the applicant has pointed out that there is some mistake in the clause title of the order dated 29/5 and the response in the column of the applicant. And as such, there is a requirement for making necessary correction. Therefore, the learned counsel both party as third one steps according to part of this time allow this application provided that in paragraph 7 after the word head and before the word engage, the word now shall be it as not for all purpose and also precisely make correct outside of the order dated 29/5. In terms of this, I
Highly obliged.
Obliged.
May I please, your lordship. Lordship, on the last occasion, the appellant sought time for filing some document relating to the applicability of the GCC 1998. Whether
Pardon?
on the last occasion, the appellant sought time for filing some application regarding the applicability of the GCC 1998.
Lordship, this GCC 1998, Honorable Court directed to produce before the Honorable Court. And Lordship, it is available with me, Lordship. I brought the copy, Lordship. And as per the GCC, Lordship, that interest part is not entitled. We are ready to pay the principal amount, Lordship. And also Supreme Court says the same thing, Lordship.
today it is already 4:30.
Lordship.
This is the date.
Lordship, next week, Lordship, otherwise first week of September. First, it is a part hard matter, Lordship.
As agreed by learned advocates of both the parties, the matter is part of order of September.
Thank you.
Thank you.
Lordship, the issue here is, Lordship, what will be the effective date of receiving graduate scale of pay, whether it would be the date of regularization or whether it would be the date of acquiring my MPhil qualification.
Awarding?
Obtaining my MPhil qualification. That is the issue here. And Lordship, similar persons have been allowed the same benefit. I am only praying for similarity of treatment. I have given all the examples of 5, 6 incumbents, Lordship, who have been granted a similar benefit. But I have been denied.
Lordship, here in this matter, Lordship, I have filed an additional affidavit today, Lordship. It has not come on record, Lordship, and we should let it come next week, Lordship. Today, Lordship, time is also.
This is the third affidavit, Lordship, they have filed.
Yes, Lordship.
By the same director.
My lord, this matter, my lord, urgency is there. So, my lord, is thought that maybe be given, my lord, because we are, my lord, eager to complete this case so that the petitioner can be at least get the relief. Because the issue is involved, my lord. Whether my appointment condition may be, my lord, differentiated from the other appointment, the advertisement of the same
in person of the same advertisement, same selection, my lord, only they subject to a different, my lord. So this is the issue. Whether I am entitled for the UGC scale from the date of my initial appointment on the basis of my existing qualification, which is my UGC qualification and prevailing qualification at the time of the state was following. That was not in differentiated in my case. So this is the issue. So we want that one short that we give only.
Also, you are in WPC number?
I am the this is 34, my lord.
WPC number?
3820. My lord, 3820.
38.
Yes.
Third, Mr. Das for the petitioner in WPC number 4151. Also, the petitioner in 3803. That's the copy of the higher education department. And you
Your Lordship, I'm appearing for UGC on behalf of Miss P. Agarwal. Dr. P. Agarwal.
UGC. The submission is filed an additional affidavit today, and the same is not filed on record. And accordingly, if I saw the matter in the next, there is a lot.
No, this is 4th. I am convenient that is 4th September, my lord. 4th September, my lord.
For September, already.
Let it be, let it be now 11 loss. 11 loss.
11.
11-9.
Must.
May I please ask your lordship? Lordship, due to some medical emergency, learned counsel Mr. A.R. Goya, he had to leave the court early today. Lordship, kindly adjourn this matter for today.
Lordship, related to family pension matter, and the family pension has been stopped by the court of order of this honorable court, my lord, since 2021, my lord. I have no other means for survival, my lord. Kindly court date and on 9th, my lord.
That's agreed by Lord
September.
Next week.
9th of September.
9th of September. Obviously.
Any other day, any other.
Which go appellant?
Last officer lordship directed me to bring to collect the name and address of the owner of the other vehicle. That I have received, lordship. Please bring it on the record. Address to number, name and address. Owner of the-
45.
Yes.
Okay, it's okay. Any good time. Great.
তো আমাকে নাই নিচে দিব নোৱাৰো তো কোনো নামটোহে বিচাৰি
When can I pick the matter? Sir,
Lordship, any day, Lordship. Any day after 1 week,
after one.
whatever is convenient.
Or, before Karnak.
Day after.
Responsible. Or order of it for by date by the party of motorcycle building registration RAS 60A 4510. Eight party parts that the license record by parking. It are all partnered with partnered with 24.
Present. 24 September.
Other the petitioner herein paying for his area salary from June 2006, my lord. My lord, he was appointed, my lord, as 70 teachers, my lord, from 29. Service completed. My lord, service completed. Service completed, my lord. Who is called BTC?
The BTC is being represented by Madam Gora.
When? Already filed. Already filed.
The elementary education also has filed their, we have also filed our.
And reply also filed, my lord.
My lord, 2nd day of August, we have filed 2017, elementary education.
The matter is ready for hearing.
Hearing.
It is listed under the.
Yes.
But the time.
Paucity of time. ma'am.
The secretary learned advocacy for the part. Okay. Okay.
Well, regarding the quashing of the matter, my lord, PP is not there. Shall we send them?
This side is absent.
Yes, that is what I'm saying. my lord. Because last time I gave an assurance because today unfortunately it has come down below, my lord.
Part Mr. Kamar. Learned only for the non-obvious. Place the matter for.
Just, my lord, just me have a look. my-
Fix item at 2 PM.
Yes, sure, sure. I do. Then I'll just take my convenient, my lord. At 2, at 11 at 2. At 2 o'clock. Itabat. May I please, your lordship? I have made my submission, Mr. Potakor was to give his response. So I think he is tied up in some other case, so can it be on 2nd of September, your lordship?
What happened?
Fourth.
Fourth.
Let's agree with my lord that advocates for both the court.
Obliged.
Obliged, my lord.
Much obliged.